Good afternoon, judges. We welcome you to the 22nd KK Luthra Memorial Moot Court 2026. We are your court masters for this room and shall be assisting you throughout the proceedings. I am Akanksha, your timekeeping master.
I am Shantanu Sharma, your communications master.
And we are extremely delighted to have you here. Judges, there are moot memorials of both the parties on your desk. There is moot compromise and the score sheet for marking the participants. We have been asked to remind you that the participants shall be marked out of 80 only and not 100, as they already have been marked for their memorial separately. Judges, with your permission, shall we commence with the oral submissions?
Yes, please. I just have a question.
Judges will be standing know that you are in number 1021. Speaker code 01 can speak next. The counsel seeks permission for code.
Greetings to the bench. If it may please the Honourable Court, the Council seeks permission to address the bench collectively as Your Honour. Your Honour, I, along with my co-counsel, shall represent the prosecution in the matter of State of Savoca versus Lucio. With Your Honour's permission, I seek permission to address the facts of the case. Nonya, may I proceed with the argument? Your Honours, the matter pertains to the death of the deceased, Anthony Corleone, who was suffering from a cardiac disability, for which purpose he had an AI pacemaker implanted in his heart, which operated by means of a transmitter. Now, it is on this day that this transmitter accidentally falls out of the pocket of the deceased and hits the ground, rendering the screen cracked. It is for this purpose that they approached the accused for the repair of the device, who, in undertaking the same, pries open the casing of the device and makes an interference, which is subsequently followed by a short circuit, and Anthony is confronted with the cardiac arrest. An FIR was thus lodged by his daughter Isabella, alleging that it is at the hands of the accused the death of the deceased has been caused. The Council seeks permission to proceed with the arguments, Your Honours. Your Honours, I shall be dealing with the issue of causation in this matter, while my co-counsel shall be addressing the issue of mens rea and the plea of general exceptions. Your Honours, in critical times, when help is sought with open hands, the law regards anyone who grants this aid with a liberal mind. But when this guise of help ends up taking the life of the very person whose death is to be averted, then the question is raised, Your Honours, is it really in the interest of the society to set the precedent of relieving one of causing another's death simply because he was entrusted to help? Your Honour, the matter at hand deals with the conviction of the accused under Section 105 of the Sarajevo Penal Code, which by way of placing reliance upon Section 100 provides for the offence of culpable homicide not amounting to murder and makes it punishable thereof. In this regard, the counsel shall firstly address that the initial requisite to constitute the offence is present in this matter, being causation of death of the deceased. Your Honours, the law regards causation to be an important ingredient to determine whether culpable homicide not amounting to murder has even been committed in the first place, as established in the case of Yashwant versus State of Maharashtra. Now, it is upon these lines that the High Courts and even the Apex Court has widely accepted and adopted the principle of determination of causation through the Latin maxim enshrined as causa proxima non est remota juris spectator, which translates to that the law must regard the proximate cause and not the remote cause. On these lines, Your Honours, it is the humble submission of the counsel that death of the deceased is a result of the most proximate cause of intervention made on part of the accused. Now, why the counsel says so is, if Your Honours may kindly refer to page number 15 of the Moot proposition. Of the Moot proposition, Your Honours. Your Honours, the document regarding the facts of the case.
Just make sure the which is this?
The Moot proposition.
Yes, yes. In this.
We have 11 pages in the prosecution.
Maybe we correct it. This one.
Of the facts, Your Honours.
I have 11 pages.
No, there was another bit here on your table.
On my table?
Yes, that has does this have it?
This one. I can share it. Do you have this?
Yes, yes, basically. We thought the booklet was the same as what was given to us. All right.
May I proceed, Your Honours?
Yes, please.
Whenever you're with me on page number 15, Your Honours,
Yes.
it provides certain warnings regarding the use of the transmitter. The very first warning providing, do not open or interfere with internal components. Device integrity is critical to cardiac life support. Your Honours, in the present matter, however, when the accused was made aware of the contents of the patient's handbook, which even the defense witness admits to him having understood, Your Honours, then his act of prying opening of the casing of the device firstly shall constitute the first and foremost violation of the directions of not just his handbook, but also Isabella, Your Honours. Regardless, Your Honours, he then even proceeds to make an interference with an internal component, which the location of which, Your Honours, if you may refer to defense witness testimony, page number 23 of the Moot proposition. Page number 23, paragraph 17, Your Honours, if you're with me. Your Honours, the third line, it lays down that this internal component was located at the very edge of the circuit board, which in itself has been admitted by the defense witness himself, concludes to be a core component. Page number 23, Your Honour, paragraph 17. The defense witness testimony, Your Honours.
Do you have a copy of this with you?
Yes, Your Honours. Can I?
So where exactly?
Your statement.
This is just the facts.
So इसमें होगा in the white volume.
Yes, but exactly what are you referring to?
The Moot proposition, page number 23, paragraph 17.
Yes.
The defense witness testimony, Your Honours.
Para 17 is memorials.
Could you mention page number since it's easier on the right hand side?
17.
23, Your Honours.
23.
Yes, Your Honours.
We have this one.
We have the one in the
This does not have page
page.
17, but the one there that is given in page
You
17.
just show it to her and this is what's on which page.
Page number 23. Page number 23, I'll show.
Stop that time of that's not
Just put your information.
No, the Moot proposition. So this.
I'll tell you, she's got double space. That's the problem. Just go with the paragraph.
So page number
Counsel,
23
the
with this is
the first
the 22nd
thing-
page, 23rd page is defense witness
Counsel,
testimony, 17th
the-
paragraph.
Counsel, the first thing when you address a court is to be on the same page as the court, both
Certainly.
literally and metaphorically.
Certainly, Your Honor.
So I don't think it's entirely your fault. I think it's the court masters who are at fault in this.
It's at page 20. It's at page 20. Have you found it?
Anyway, you can read it.
It's page.
Yes,
I can read the same, Your Honor. Yes, Your Honor.
It's page 20. You're reading DW1,
Yes, Your Honor.
page 20.
Page 23, paragraph 17. Shall I read out the same, Your Honor?
Yes.
The third line, Your Honors, lays down that this connector was along the edge of the circuit board, which is an admitted fact and not one which the prosecution is developing on its part. If Your Honors are with me, I'll just read out the
We have found the deposition of witness number 1. Which
Yes.
paragraph do you want to read?
17th
Go by
paragraph.
pages, just go by deposition.
Right. 17th paragraph. It starts with there is always a chance.
Yes, page 21. Okay.
Yes. The third line, if Your Honors may read, the connector was along the edge of the circuit board. Right. Certain. Now, Your Honor, this is a fact which is not developed by the prosecution. It is admitted by the colleague of the accused himself. Now, the sustenance or the significance that the counsel shall place by reason of this fact in itself is that when an interference with an internal component is made, which is not only at the edge of the circuit board but is accessed only after opening the casing of the device, it shall amount to a gross violation of the directions of the patient's handbook, Your Honors, and the consequence shall necessarily warrant the death of the deceased. Additionally, to the matter of causation, Your Honors, if the cumulative appreciation of the chronological order of events is made. So why, Your Honors? Because it is only after this intervention is made with this transmitter and its internal component, Your Honors, that the deceased began exhibiting symptoms of cardiac distress. Throughout the whole course of repair,
Only saving a life.
I understand, Your Honors. Your Honors, if you may kindly permit me to address this fourth of the argument, and I shall continue to address Your Honors' concern. In solely to establish the causation, Your Honors, it is to be understood that this act in itself, Your Honors, when was proceeded with immediate symptoms of cardiac distress, a short circuit, especially when no such symptoms are available or even seen throughout the whole course of the repair, or even when the transmitter initially fell out of the pocket of the deceased, the submission of the counsel is that the most proximate cause of death of the deceased shall be intervention made on part of the accused. At this juncture, it is necessary that the counsel shall clarify and actually establish that this component definitively constitutes an internal component. Now, why the counsel says so is because if Your Honors may kindly refer to the queries and clarifications number 35. If you would want, the counsel shall read the same, Your Honors.
Now, where will we find that?
Your Honors, the queries and clarifications, the 35 number.
Yes, the 27. Now, which part of this?
35th clarification, Your Honors.
25th.
35th.
Yeah, 35.
It provides for what does an internal component given in the Moot proposition refer to?
Yes.
Your Honors, it is to be noted that this clarification lays down that there are three requisites to constitute an internal component. Firstly, Your Honors, that it shall be located inside the device. Secondly, that it shall be essential to functioning of the transmitter. And thirdly, that it shall be essential to communication with the implanted pacemaker. Now, Your Honors, the apparent positioning of this component inside the device and at the edge of the circuit board shall firstly render the first requisite fulfilled. Now, pertaining to the second and third requisite, pertaining to essentiality of communication and functioning of the transmitter, the fact to be noted herein is that when an interference with this component is made, it renders a short circuit so powerful that the whole transmitter is rendered dysfunctional, Your Honors, which is in itself lays down that this internal component was so critical to the functioning of the transmitter that it led to the very death of the deceased due to the disruption in signal transmission caused by the transmitter having been turned off, Your Honors. Now, Your Honors, this in itself lays down that the most proximate cause herein shall be the act of the accused. Alternatively, an additional submission that the counsel shall make herein He said, except this submission, no other hypothesis or a parallel and equally attributable cause can be attributed to death of the deceased. This is because, Your Honours, if the premise is followed, the death of the deceased in this matter is a result of the disruption in signal transmission to the implanted pacemaker, then, Your Honours, the contention may arise that this disruption may as well be found in the damage caused to the transmitter when it initially fell out of the pocket of the deceased. However, at this juncture, it is to be noted that when this transmitter was brought to repair to the accused, he himself admits that the issue is limited solely to the display of the device. If Your Honours may refer to the prosecution witness testimony for the same, paragraph 18, Your Honours. Whenever Your Honours are with me. May I read out the same, Your Honours?
How does the sentence begin?
Your Honours, after examining the device,
Page 18.
may I read the same, Your Honours? After examining the device, Lucio told us that the damage appeared limited to the display and that the device would be shut for no longer than 30 minutes. Your Honours, the issue was limited to the simple display of the device. It at no juncture establishes that the transmitter was dysfunctional. The transmitter was functional to the extent of signal transmission, which is its main purpose, Your Honours, to the implanted pacemaker. And thus, when the transmitter was functional, and it is only after the intervention made on part of the accused, the death of the deceased has been warranted, the only possible cause of death of the deceased shall be the act of the accused. On relevant grounds, the Honorable Apex Court has also laid down in their judgment, Your Honours, in Syed Akbar versus State of Karnataka, that when no other hypothesis is raised, save that of the accused's guilt, given consideration of the chain of events, Your Honours, then shall only be the accused's guilt that shall be made culpable in this matter, Your Honours. And since no other hypothesis has been raised on part of the counsels, Your Honours, then the only and sole causative factor in this matter shall be the act of the accused. If Your Honours have any question, I shall address the same, Your Honours.
If the problem was only with the screen and the display, and otherwise the device was functioning all right, why did you go to this mechanic at all?
Your Honours, if you may refer to the facts of this matter, Your Honour, the 13th paragraph, Your Honour. It starts with Isabella and Anthony immediately considered. Are Your Honours with me?
Yes, please.
Your Honours, the third line reads, concerned that the damaged screen could affect the functioning of the transmitter or shut it down, Anthony and Isabella proceeded to the store, Your Honours. Your Honours, the submission of the counsel is that Anthony and Isabella had approached the store solely to have the risk or the assess matter, Your Honours. It is not that they had believed that the transmitter is dysfunctional and repair was warranted. It was a mere assessment of risk, Your Honours, made on part of Anthony and Isabella out of sheer concern. And that is the sole reason for which they had come to the accused, Your Honour, who then makes an interference on his part after having made the complete inspection of the device and having understood the nature of the device, Your Honours.
That's his preliminary access. Looks at the device, finds something wrong. He doesn't know what it is.
Go into the machine and then find out what is the real cause. And in that, many things can happen. So how did he really assess that what is the real problem here?
Your
Because
Honours,
the screen was broken.
certainly.
The screen was broken. He felt that this is the problem with the screen. And as a normal technician, he'll say, okay, it looks like a screen problem. I'll look into it. And while doing that, it must have occurred. And he's only trying to help, as I'm saying.
Certainly, Your Honours, I can understand the concern. However, a chain of events need to be considered herein, being that when the accused was provided with this device, thorough detailing of the same was provided by Isabella, Your Honours. She had repeatedly told him that it was critical to the life of the deceased and that if any damage was made with this device, then the life of the deceased shall be confronted with the cardiac failure, Your Honour.
That's the reason he's helping.
Certainly, Your Honours,
But
I understand the
equally-
concern.
But equally concerning is the fact that Isabella and Anthony did not carry the backup transmitter with them. This
Right,
could
Your
happen
Honours.
anytime, anywhere. What if you hadn't found Lucio at all and there was nobody there? Then what would you have done?
Your
So if you
Honours,
say the chain of events, then why don't you begin at the beginning of the chain?
Your Honour's causation needs to be understood herein. Now, if this fall of the transmitter, having been occurred due to an accident, is to be considered herein, then it is necessary that this causation also triggers the chain of death of the deceased, Your Honours. The consequence is not the same. The death is not caused by the fall of the transmitter. Additionally, pertaining to the addressal that Isabella fails to carry the transmitter, to this, Your Honours, it still does not relieve the accused of his liability. Since in this matter, Your Honours, when Isabella fails to carry the same, Your Honours, which is an honest mistake that the counsel shall admit to, Your Honours is still considered rushing home to retrieve the backup transmitter which the brother was bringing along. Additionally, Your Honours,
Was Lucio an expert in repairing this atrial device?
Your Honours, Lucio possessed an experience of 15 years in related devices such as health monitoring wearables, ECG patch modules, and Bluetooth-enabled vital trackers.
Did he specialize in atrial link system?
Your Honours, atrial link system is a proprietary device and does not resemble.
Why did you go to him?
Your Honours, that was the mere assessment of risk. As the counsel shall contend, Your Honours, the same purpose for which they had went was the mere assessment of whether any actual damage was caused to the transmitter pertaining to signal transmission.
For
And that
which he
was
had
the
to open it.
It is not necessary, Your Honours, especially when this opening has been done after consent pertaining to display has been provided. That is the whole submission of the counsel.
Now see, there is a contradiction in your argument. Anthony, Isabella were not sure if the damage was only to the screen and display or whether there was something deeper.
Certainly.
That was the matter. If they had been sure that it was only the display, they would never have gone anywhere. They would have taken the deceased home and then used the backup transmitter.
I
So
understand.
when you were not sure, how could Lucio be sure? And even the process of repairing it, as Justice Narula is correctly saying, he was only trying to be helpful.
Certainly, Your Honours.
He may have been responsible for further damage to the device, but not for the death of the deceased.
Your Honours, the counsel shall reiterate that, Your Honours, at this juncture, knowledge of that of Lucio, the accused, who is a senior technician, shall not be imputed to the Isabella, Your Honours. Isabella is a mere person who had the responsibility of informing the accused about the nature of the device, about everything which was critical to the same. But that does not impute the knowledge that is expected out of the accused in this matter by reason of the responsibility endowed upon him. The standard of reasonable care that was
That is
expected.
not remote enough as a cause.
That is exact. If Your Honours, I may just permit for 5 minutes more, Your Honours. Just the last submission.
Yes, please. Yes, please.
Your Honours, to this it is submitted again that causation needs to be understood. The fall of the transmitter or even handing over the transmitter for repair only till the extent of display repair, Your Honours, does not in any matter amount to an intervention such that it can be causative of death of the deceased. If we are considering any remote cause, Your Honours, then the probable cause or consequence of such act shall be the death. However, the fall of the transmitter or Isabella approaching the accused does not in any manner warrant the consequence to inevitably be death. However, the consequence that does warrant death in this matter is a violation of the directions of the patient's handbook and Isabella made on part of the accused, which is the intervention with the internal components, Your Honours. And that in itself shall suffice to be the sole hypothesis that shall give rise to liability on part of the accused, Your Honours.
Madam Prosecutor, I have a question for you. In the statement of facts at paragraph 9,
Certainly, Your
the
Honours.
hospital had advised the deceased that the transmission should not stop for, only if the transmission stops for longer than 60 minutes, it could be fatal. Then your statement of facts say that he actually passed away within 40 minutes of the fall of the transmitter and not after the short circuit. In these circumstances, how have you medically proved that the causation was the absence of signals? You have not laid any expert evidence on this. You're only relying on the say-so of the complainant. How do we even establish that this happened because of the fall of the transmitter or the short circuit?
I understand the concern, Your Honour. To this, it is to be noted that if we read this line, Your Honour, the absence of signals, if Your Honours are with me, the absence of signals transmitted through the pacemaker for longer than 60 minutes pose a direct and life-threatening risk. Your Honour, this 60-minute duration did not imply definitive sustenance of the deceased, Your Honours, in this matter. This duration of 30 to 40 minutes or any juncture at all, when intervention with internal components is made, death is a warranted result, Your Honours. Therefore, Your Honours, when death is a warranted result between any time span, up till the 60 minutes, especially in particularly after that, Your Honours, death shall be likely in a more probable consequence in this matter, Your Honours.
But madam, this statement of fact was a medical opinion, right?
Certainly.
Paragraph 9 given by the doctor. So where is the medical opinion on record which says that yes, this happened because the transmitter malfunctioned at 40 minutes?
Your Honor, since the Moot proposition is silent upon the same, the counsel shall rely upon the testimony of the defense witness, who was a senior technician and the colleague of the accused, who himself having understood the nature of the device because he was present at the very matter, Your Honors, and then it also provides in his examination that he understood the criticality of the nature of the device and also admits that Isabella clearly laid it down to the accused that if prolonged disconnection is made or any intervention is made, then that shall be the consequence, Your Honors.
I understand, Madam Prosecutor, but how can the defense statement amount to the proof of causation? That's the question. Because the burden of causation is on you. And has it been discharged with DW1? With the PW1?
Your Honor, that is the submission of the counsel, that causation shall only be reliant upon on the chain of circumstances. In this matter, Your Honors, because no other hypothesis can be given rise to, and the most last act and the most proximate cause herein, and the most substantial actually, being a violation of the directions explicitly laid down to the accused, shall warrant death of the deceased, Your Honors. If I may have the permission to call upon my co-counsel to address the issues, Your Honors. Much obliged, Your Honors.
Greetings, Your Honor. This is the second counsel appearing on behalf.
Just give me a minute.
Surely.
तो ठीक है
Shall I proceed, Your Honor?
Yes, please.
Your Honor, this is the second counsel appearing on behalf of the prosecution in the case of State of Savoca versus Lucio. I shall be addressing the issue pertaining to mens rea and the application of general exceptions with your permission. Your Honors, when the time of panic strikes and death hovers, any act done to save one's life is relieved of all heavy burden of responsibility if it is done in all bona fide belief. However, when the same act is undertaken in utter disregard of the consequences that shall ensue and the care that should have been undertaken, specifically with presence of knowledge of likelihood of the consequences, then the same protection cannot be granted, which is why this particular case requires your kind perusal. And this is why the counsel stand before you to establish as to how the accused shall be imputed with the requisite mens rea, manifested in form of knowledge of likelihood of death of the deceased in this particular case, Your Honor. With this regards, the counsel shall place reliance upon the definition of knowledge provided by the Honorable Supreme Court in the case of Jayaprakash versus Delhi administration, wherein knowledge was defined as a state of mental realization in which mind is a passive recipient of certain ideas or impressions arising in it. It connotes the bare awareness of consequences of one's conduct. Further, in the case of Kesar Singh versus State of Haryana, the term likely was understood to be probably and not possibly. So now the counsel shall from this understanding highlight the first and foremost and most important fact to Your Honors, that the accused possessed a considerable experience in his field, particularly with similar health monitoring wearables such as ECG grade SPAT modules and Bluetooth enabled vital trackers. So it was reasonably expected out of him to not only understand the criticality of the undertaking of the repair, but also be cautious in maintaining the health of the deceased, Your Honor. More importantly, if you may refer to page number 5 of the Moot proposition, para 16, Your Honors. Isabella tells the accused about the nature of the device and its functioning by virtue of it being implanted in her father's heart. She further tells him that any prolonged disconnection or malfunction can lead to sudden or fatal cardiac arrest. If Your Honors are with me. Further, Your Honors, not only this, reasonably fearful of her father's life, she even inquires as to whether the accused will even be able to undertake the repair in the first place or not. A fact reiterated on page number 5, paragraph 15, Your Honors. If I may read the same for you. She asked the accused if he could repair the device without shutting it down for too long and without damaging the device. Further, Your Honor, in her testimony also she testifies that she asked the accused if he could safely undertake a display repair, Your Honors. Thereafter, she provided to him the patient's handbook for his further aid. The very first warning of which on page number 15 provides that warning, do not open or interfere with the internal parts of the transmitter. Device integrity is essential to cardiac life support. It is thereafter that the accused, on the bare external perusal of the device, assures them that the issue appears limited with the display of the device and that he shall be able to undertake the repair without interfering with the internal parts of the transmitter, Your Honors. It is thereafter that Isabella consented to only a display-related repair. Post which, at the juncture wherein he pries open the casing of the device, going against the very first warning of the patient's handbook, it is submitted that he notices a connector dislodged at the very edge of a circuit board. Your Honor, it is submitted that this wire that is dislodged is in only the observance of the accused a display connector. There is no argument or no fact that shall reiterate that he could have understood as to why he shall undertake the same without him having the knowledge of the internal circuitry of the transmitter. Your Honours, for this the counsel shall rely on the fact that he lacked any schematics of the internal circuitry of the transmitter, regardless of which he proceeded with the unwarranted and unauthorized repair, Your Honours. Firstly, if he knew that the issue appeared limited with the display of the device, Your Honour, is it not reasonable of us to expect of him that when he has the knowledge that he shall not open or even interfere with the internal parts of the transmitter, that he should have advised that it was not within his capabilities to undertake the repair in the first place. And therefore, when he makes such a manipulation of such a critical component of the device, Your Honour, there shall be an imputation of knowledge of likelihood of the death of the deceased. And therefore, the essential requisite of mens rea manifested in form of knowledge shall be rendered fulfilled, Your Honour. If you may have any questions with regards to this issue.
Madam, did you summon the witness from the manufacturer Atria link system, and did you have this device examined by them?
Certainly not, Your Honour. The same is not present in the fact sheets and the Moot proposition.
Okay, so in the absence of that, all the conclusions that you have drawn, or the fact that, whether this amount, whether whatever action he took amounted to violation of the warning, did it actually take effect? Is there any evidence on record with this respect?
I apologize, Your Honour. Since the Moot proposition does not allow us to go beyond the facts, it is the contention of the counsel that if we see the chain of events that have so occurred, that by virtue of reconnection of a connector placed at the very edge of the circuit board, admitted by the defense witness, who is also a technician, to be a core component, a short circuit immediately ensues. Thereafter, immediately the deceased shows symptom of cardiac arrest. When rushed to the hospital, he was confirmed to be in the cardiac arrest, wherein he succumbed to the attack, Your Honours. And therefore, it is a logical deduction and conclusive proof as to the chain of, with regards to the chain of events, that itself established that the death of the deceased was a direct act of the manipulation made on part of the accused, Your Honour. Shall I proceed with the arguments? Other contentions that the counsel shall now negate would be that none of the general exceptions under Chapter 3 of the Sarajevo Penal Code shall come to the aid of the accused, Your Honour. The sections that can be invoked in this case are Section 18 being accident, 19 being necessity, and 25 and 26 pertaining to consent, Your Honour. However, all of these essential requisites of these sections shall not be fulfilled in the facts and circumstances of this case. This is, firstly, with regards to accident, Your Honour, it is submitted that the same would mean that something unforeseeable or unexpected happens out of ordinary course of nature. However, it is the contention of the counsel that when the act of the accused of reseating a wire placed at the edge of the circuit board is deliberate and consciously undertaken, specifically with cognizance of the fact that fatal consequences shall ensue by virtue of any manipulation or prolonged disconnection, then the same is a direct and forcible result of his act, Your Honour, and therefore it will not be a mere fortuity so as to qualify for constituting an accident. Further, the same would not even constitute a misfortune, Your Honours, because the same would mean an adverse event or calamity or evil fortune that arises out of accident or is not being able to be guarded against by ordinary care or prudence. However, when the counsel has already established that the act of the accused was undertaken deliberately and consciously, then the foundation of laying down that this act was a misfortune shall also fail. Further, the essential requisites required proving under Section 18 will be: secondly, that the accused undertook the act by employing lawful means in course of a lawful act in lawful manner. Other requisites that require proving are the exercise of proper care and caution, Your Honour. With regards to the requisite of lawfulness, Your Honour, it is submitted that when Section 100, being the governing law in the facts and circumstances of this case, and the essential requisites of this section, being knowledge of likelihood of death and causation, are themselves fulfilled, then the inherent nature of the act of the accused becomes unlawful. Thereafter, when the manner and means that he employed in course of doing an unlawful act, particularly going against the consent that he was provided with and outside of the professional domain of the accused, then the same shall be construed to be an unlawful act, Your Honour. Further, with regards to the contention of proper care and caution, Your Honour, the same would mean that the standard of care that is required would be judged upon the facts and circumstances of each case, as also held in Shankar Narayan Bhadolkar versus State of Maharashtra. In this particular case, Your Honour, the standard of care that was required was not merely generic. This is since the risk that was involved was not merely electrostatic or cosmetic. It was regarding the entire functionality of the transmitter and undertaken with full cognizance of the fatal consequences. Thereafter, Your Honour, when the accused only employs generic precautionary measures, such as use of anti-static gloves or non-invasive tools that he would have undertaken in even a routine repair, regardless of the nature of the device, which in this case was a proprietary device, Your Honour, when he undertakes an act in lieu of the absence of schematics of the internal parts of the transmitter, and thereby proceeds with such an unwarranted reconnection, the same shall not suffice to constitute proper care and caution, and therefore protection under Section 18 cannot be granted to him. Further, Your Honour, protection under Section 19 can also not be granted to the accused. This is since for this, it has to be proved that the act of the accused was undertaken in good faith and for the purpose of prevention or avoiding an imminent harm. Your Honour, with respect to the contention of imminent harm, it is submitted that there are reasonable legal alternatives present in the patient's handbook. It is the contention of the counsel that when there are reasonable legal alternatives available, then the choice to disobey the law becomes a voluntary one, as also held in the case of Perka versus the Queen. Your Honour, it is the contention of the counsel that when the accused understood that the issue appeared limited with the display of the device, and he understood that he shall not open or interfere with the internal parts of the transmitter, and that he shall not be capable enough to undertake the repair without opening the transmitter, that is it not reasonable for him to advise such stipulated remedies to be taken by the Isabella and Anthony. Further, at the juncture when he sees that a connector is dislodged at the edge of the circuit board, he does not once peruse them or ask them as to whether he shall proceed with this manipulation or not. He does so with full cognizance that the same shall constitute interference with the internal parts, Your Honour. And therefore, the purpose of the accused herein would not be to prevent or avoid an imminent risk of the transmitter going dead, Your Honour, since he himself observes that the issue is with the display of the device. Further, Your Honour, with regards to the requisite of good faith, the same under Section 2, subsection 11 would mean nothing is done or believed in due care and in good faith if it is done without due care and attention. By virtue of the earlier argument that the counsel already stated, that the standard of care required in this case was not exercised by the accused by employing mere generic precautionary measures that he would have undertaken regardless of the nature of the device, and he is undertaking the act with full knowledge of the fatal consequences, then the same shall not suffice to be an act that is construed to be undertaken in good faith, Your Honours. And therefore, Section 19 cannot also come to the aid of the accused. Lastly, Your Honour, it is the contention of the counsel that Section 25 and 26 pertaining to consent also cannot relieve the accused of his burden. This is since both of these sections require a common requisite of consent. Herein, Your Honour, in this particular case, the consent that was provided to was limited and conditional, limited to a display-related repair only, for which, if Your Lordships may refer, if Your Honours may refer to page number 6, para 19. third last line, Your Honor, she requested that the accused handle the repair with extreme care, ensuring that no damage or disruption was caused to the transmitter. Further, on the same page, she asks, relying on the accused's demeanor and assurances, Isabella agreed for repairing the transmitter. So herein, it is the contention of the counsel that the consent that was provided to was within the limited circumscription of a display-related repair, Your Honor. When the accused opens the transmitter and manipulates an internal part of the transmitter, then the same consent is transgressed with, Your Honors. Further, even when the argument is followed that the consent was given, it is submitted that the consent of death was not given, Your Honor, or to undertaking of the risk of the death. Herein, the consent was only for a display-related repair. Further, even this limited consent shall not come to the aid of the accused under section 25. This is since when the act is undertaken with knowledge of the accused, the section cannot be applicable. A principle reiterated in the case of Queen versus Punai Fatima, wherein a snake charmer induced the person to be bitten by the snake with his consent. However, the Honorable Court noticed that when the accused possessed the knowledge that death was a likely consequence of his act, offense of culpable homicide not amounting to murder, done with knowledge, shall be what the accused shall be liable with, Your Honors. Further, Your Honors, with regards to section 26, it has to additionally be proved that the act is done in good faith and for the benefit of the person concerned herein. But it is the contention of the counsel that when the accused knew that his act would formulate an interference with the internal parts, and thereby he is expressly warned against these same, not only by the contents of the patient's handbook, but by warnings of both of Isabella, then the same shall not be construed to be an act that is done with the benefit of the deceased, Your Honors. If you have any questions, I would like to entertain them.
You are insisting on internal mechanism being tempered.
Rightly, Your Honor.
But this was displayed in the short circuit.
Certainly.
Not going inside.
So-
Reconnecting the circuit.
On the edge of the circuit board.
Certainly.
Short circuit. Not going inside.
Cert-
Which is inherent short circuit.
Indeed, Your Honors. For this, firstly, I shall refer to the very definition of internal components provided in the clarification. By virtue of the mere placement of that supposed display connector inside the device, it shall formulate an internal component. Secondly, Your Honor, it is placed at the very edge of a circuit board. Herein, the accused has no knowledge of internal schematics of the device, and he does not know as to whether he will be able to connect the display connector that he so observed without interfering with the circuit of that at the edge of which it is placed. Further, Your Honors, it is the contention of the counsel that when the accused knew that he shall not open the transmitter, then the same shall amount to an interference. Further, with regards to the Moot proposition saying that in course of reconnecting a display connector, it is submitted that the preceding line of the same paragraph says that the accused observed a display connector to be dislodged. It is the mere observation of the accused based upon the constituents and placing of the internal parts of the transmitter. Herein, it is to be noted that he did not have any access to any internal layouts. So it is just a mere assumption on his part that the same would formulate a display connector, regardless of which, if he sees that it is placed at the very edge of a circuit board, if he proceeds to do and reconnect the same connector and interferes with the same, then the same shall constitute an interference with the internal parts, Your Honor.
But again, as Justice Arora asked you, you have not had any expert witness depose to the fact that in order to repair the display, you might have it might have been necessary to open the device. Nobody said that it wasn't necessary. And also, there seems to be. Did you conduct a post-mortem on the deceased?
The same is not provided for in the Moot proposition.
So cardiac arrest means what? Everybody who dies suffers a cardiac arrest. At the end, the heart stops. So whether the cardiac arrest was definitely and positively a result of this pacemaker not having been functional, we don't know.
Certainly, Your Honor.
And as was pointed out, the man died in 40 minutes. And they said that if you switch off this atrial system for longer than 60 minutes, then he will die. There's no, that's not the position at all. So neither the cause of death nor the mistake on the part of Lucio to have opened the device, nor the connection between the device not functioning and the death happening, all these three ingredients are absent.
Since
There's
I'm
no evidence to that.
Rightly, Your Honor, and since I'm not allowed to go beyond the moot proposition, my argument shall be placed. I shall place reliance upon the fact that the chain of events herein occurs in a fashion that I may reiterate that the deceased was perfectly fine up until a short circuit had occurred, Your Honors. The fall of the device till the repair had been undertaken by the accused and the reconnection was made, the deceased was absolutely fine, showing no symptoms of cardiac arrest. Albeit he was in a state of panic, but that does not impute the symptoms of cardiac arrest. Further, Your Honor, when the accused himself admits that the issue is with the display of the device, and then he goes beyond what the display shall constitute and interferes with the internal components, immediately thereafter a short circuit had occurred. So even when it is provided that still 60 minutes sustenance will be done, it is submitted that that is not the terminal end. And further, there are reasons as to why the patient's handbook particularly provide that interference shall be not made with the internal parts of the transmitter, because it is fatal to the deceased, Your Honor. And therefore, when a manipulation is made, a short circuit had occurred, and immediately thereafter, the deceased shows symptoms of cardiac arrest, then the same shall lead to a logical deduction, and that cannot be negated by my learned opposition counsel, that it happened by virtue of any other hypothesis that they can raise. Those hypotheses can be that the same happened when the fall had occurred. But Your Honors, the accused himself observes that the issue is with the display. He himself observes that the deceased is absolutely fine up until then. Thereafter, even the age and ailment of the deceased cannot come to the aid of the defense counsel, Your Honor. This is since he was functioning absolutely fine after the pacemaker was implanted in his heart for several months. On the day of the incident also, he was absolutely fine up until only the reconnection was made and a short circuit was occurred. And therefore, causation shall be imputed to the act of the accused, Your Honor.
Madam, you just concluded by saying that this is the most logical deduction to make, right? But in this trial, you have the onus of beyond reasonable doubt. So do you think the words logical deduction meet that onus?
Your Honor, by virtue of saying logical deduction, I just meant to say that I wanted to circumscribe myself to the moot proposition. And what my argument shall be reliable upon is the chain of events. And when chain of events is itself conclusive enough to show that the act of the accused is the causation of the death of the deceased, then the criminal liability under section 105 shall be affixed upon him.
But we just pointed out all the aspects of doubt that may arise. Short circuit, by its very definition, is not something which is caused intentionally. It happened, right? So he may have been intending to repair the device, and just the knowledge that if the device shuts down, but it would have shut down had he not repaired it also.
It is the contention of the counsel, Your Honor, that when the transmitter is functional and only the device, the display of the device is not functional as observed by the...
You weren't sure of that. You yourself weren't sure of that. Otherwise, you would never have gone to Luthra.
Certainly, Your Honor, with regards to which I shall submit the concern that the damaged screen could affect the functioning of the transmitter. So we knew the screen is damaged, but the extent of the damage was not known to the customers. Thereafter, it is on the assurance of the accused that they believe that the issue is with the display of the transmitter, Your Honor. And
yes.
And therefore, Your Honor, causation shall be imputed to him by virtue of all the other hypotheses being negated by the counsel. Shall I proceed with the prayer of the case?
Yes, please.
Wherefore, in the lights of the issues raised, arguments advanced, and authorities cited, may this honorable court be pleased to convict and sentence the accused of the offence of culpable homicide not amounting to murder, done with knowledge of likely consequence of the death of the deceased under section 105 of Seragio Penal Code, all of which is respectfully submitted to this honorable court. It was an honor to plead before you, Your Honor.
Yes, please. Can you just give us the speaker codes of the earlier two speakers again, please? It was 1021. The team was 1021. You said 02 for this one? Yeah.
Council seeks permission to approach the dais.
Yes, please.
Just a minute, please. With utmost respect, the council seeks permission to address the bench as my lords. Please, my lords. Your Lordship, the Speaker 1 will be addressing issues 1 and issue 2 concerning intention and knowledge with regards to section 105 of BNS. However, the council 2 would be presenting issues 3 and issue 4 concerning causation of the act as well as, my lords, general exceptions. Please, my lords. The council seeks permission to directly address the arguments at once if your lordships are well versed with the facts. Please, my lords. Well, this case begins with a rare device as an experimental technology and a tragic death. But however, the prosecution mechanically inserts knowledge, an act which was likely to cause death, my lords. Why, my lords? Simply because physics misbehaved inside a rare device? Or, my lords, is it to compensate the guilt inside the complainant's mind for not acting prudent and rather acting as a catalyst to death, my lords? Your lordships, the case at hand can only and only be understood if your lordships today analyze the essence of section 105 Bharatiya Nyaya Sanhita. Well, this statute consciously bifurcates into two parts. Part 1 being warranting an intention to cause death, my lords. However, part 2 merely requires knowledge of the act which is likely to cause death, my lords. But the present issue at hand deals with how part 1 fails to apply in the present case, my lords. Well, it's the present issue at hand, the essential ingredient in the issue, which is the intention to cause death, is something which cannot be derived mechanically. One has to ascertain the fact that it is a question of fact in itself. One cannot go into one's mind for deriving intention, my lords. However, the honorable courts of this country has consistently derived a non-exhaustive list to infer if a person has intention or not, my lords. Well, the Honorable Supreme Court in Nagaraja Reddy versus State of Andhra Pradesh enumerated some factors to be considered to derive if one has intention or not. Well, there are some factors
Counsel,
which are...
Are you sure you want to spend time on 105 part 1? I don't think intention has been argued.
Please, my lords.
Lucio did not intend to kill Antony.
Please, my lords. Well, it's the charge
He is
at...
imputed in having knowledge
Please, my
that
lords.
what he was doing
Please,
is
my lords.
likely to cause Antony's death.
Please, my lords.
So I don't know why you want to spend time on part 1.
Please, my lords. My lords, the council here has 2 points to make with regards to this. First point being, the charge at hand is 105, my lords, in its entirety. So to defer the whole culpability, the council were addressing the issue. However, my lords, I certainly understand what the lordships want. Hence, this particular council would straight away move to the knowledge part to defer the culpability under part 2, my lords. Your lordship, let's understand the case in a very chronological order, my lords, to ascertain if at all knowledge is present or not, my lords. Well, it's interpreting the ingredient of knowledge in itself cannot be done independently. It needs to be interpreted with the act in consonance, my lords. If at all it is independently interpreted, it would be utmost draconian, my lords. And the knowledge should be of such nature to find culpability. The nature should be an act which would likely to cause death, my lords, not the other way around. Well, it's the knowledge in the present case were not of such nature that it would at most act likely to cause death. However, the knowledge was just provided to the fact, confided toward the fact that it was to prevent death and not to cause death, my lords. How I'll just explain to my lordships, my lords. If your lordships can have para 15, page 5 of the Moot proposition. Does your lordships have me on the referred page? Well, as it states that Isabella told the accused that the screen of the transmitter was cracked and the display was not working. And furthermore, if your lordships can move to para 16 of the Moot proposition minutes. Does your lordships have me on the referred page? Well, as Isabella told that any malfunction or prolonged disconnection could lead to cardiac failure or even sudden cardiac arrest. Malads, the emphasis should be on any. Malads, now the thing is that malfunction is already existing in the device, Malads. The screen has broken down. So the malfunction indeed exists. And this very point can lead to cardiac death, Malads. This is what the accused anticipated, Malads. Now, Malads, coming to the knowledge part. If your lordships can have page 20 of the Moot proposition. Well, this is the statement of DW1. If your lordships can have para 11 of the same minutes. Does your lordship have me on the referred page? Well, let's read it together. Well, the DW1 says that Lucio told him, this could be why the screen isn't coming on. I think it's safe to reconnect this. Otherwise, the transmitter might end up dead entirely, Malads. Now, Isabella has been constantly reiterating a fact. And the fact is, if this particular device shuts down, it would ultimately lead to death. Now, Malads, my knowledge in the present matter, which was being showcased to me by her, was that any malfunction, if prolonged, Malads, it would ultimately lead to what? Cardiac arrest situation and the transmitter ending up dead entirely, Malads. Now, Malads, inferring such knowledge to prevent death into something called as knowledge to cause death would be utmost erroneous, Malads, and that is what the drafters feared, Malads. Now I'll just prove how and where is this coming from, Malads. Malads might agree on the fact that BNS is the very derivation of Indian Penal Code, and the very Indian Penal Code is born out of the genesis of originally drafted Penal Code by Lord Macaulay, Malads. Malads, while deliberating and while debating on the fact of knowledge, Lord A.D. Campbell said that likelihood in knowledge to prevent death should never ever be inferred as likelihood to cause death, Malads. Because if that likelihood is inferred as likelihood to cause death, it would be erroneous, and that is why they told explicitly to the Law Commission to disregard this kind of knowledge to be culpable in the same act, Malads. And this very much is present in the originally drafted penal codes, Malads. Malads, let's understand one more thing. Chronology of the facts, Malads. The complainant comes to the accused. For what, Malads? For getting the device repaired. Malads, let's take an analogy now. If a person is dying alongside the road, Malads, an ex-person sees him dying with a cardiac arrest, Malads, and goes to help him, Malads. And while helping him, tries to give him a CPR. Or let's assume he starts pressing and pumping his chest, and while the said act, Malads, he breaks a rib in the whole process. Malads, will he be also found culpable of the fact? All he was doing, what knowledge did he carry, Malads? If I don't do something, then this person would die, Malads. Now, Malads, the prosecution has conveniently claimed that we could have said no. We could have done this. However, Malads, there's something which needs to be considered. Malads, the complainant's father is in the picture, Malads. The father, Malads, she's the daughter of the person who got deceased, Malads, who is the deceased. She herself is coming and saying, what will I infer from this, Malads? She has a 2-week training program to handle this device.
15 years of experience.
Please, Malads. Malads,
Only 2 weeks.
please, Malads. Please, Malads.
If you look at the device device and you found that it's only wrong with the display device, you could have said the patient is fine, the device is fine, please take it. Otherwise, this is a sensitive device. If I touch it, there could be an accidental short circuit. It will be further harm. That's what they expected from you.
3 minutes.
You said, okay, I'll experiment with it and I'll see what is inside. I might just, it's a new device, let me play my hands on it.
3 minutes. Well, to answer this question, there are two factual scenarios which your lordship should consider today, minutes. The first being very simple, minutes. The clock is ticking. I am on borrowed time, minutes. This person is on borrowed time, minutes. I have to anyways act. Now, minutes, your... Minutes.
We could accept the fact.
Please, minutes.
The machine was not down. It was only, with your experience, could analyze and comment that this is only a display.
Please, minutes.
Let's say that machine is fine, display problem. Take it.
Please, minutes.
Wouldn't that have been the better course for action for you?
Minutes, I humbly seek to differ from the point of view raised by your lordship, minutes. How I'll just explain, minutes. First, minutes, the first thing which your lordship pointed out is exactly what the accused told, that this looks like a screen issue. However, I can fix the screen issue, minutes. I never wanted to interfere inside the components. Never. And never did, minutes. I strictly confined my knowledge. One more thing, minutes. If your lordship can have para 6 of the Moot proposition, minutes, which is on page 4. Minutes, does your lordship have me on the referred para and page? In the 4th line, it's written mobile transmitter. Minutes, it's a mobile transmitter. Now the accused has requisite knowledge to deal with mobiles, minutes. It's a mobile-based transmitter. I just explicitly confined myself to the knowledge of screens. Nothing more, minutes. Now, certainly not, minutes. However, the accused has worked on medical graded device, minutes. Has worked on electronics like mobiles earlier also. But minutes, there's one more factor to consider. Minutes, the prosecution has circled around the fact of short circuits. Minutes, the counsel here is not an expert of physics. However, knows elementary level physics to a point that the most common part of having a short circuit is when circuits gets exposed to moistures and dust. Minutes. Simple. Minutes, the screen broke. The device broke. Not by me, minutes. By the falling of the accused, by the falling of the deceased as in itself, minutes. When...
It's not the evidence on record.
Certainly, minutes.
In fact, your colleague, Mr. Denver,
please, minutes,
says in his cross-examination, the screen was cracked, but the casing did not appear to be dented or tampered with. How did the screen crack? Well, it could have fallen on the screen and that could have been cracked. So does that mean that the device was broken?
Minutes. A reasonable understanding needs to exist here, minutes. That this device in itself is a rare device, minutes. This device is of utmost sensitivity, minutes. A device which falls and ruptures to an extent that the screen and display is totally gone, minutes. The possibility still exists that the device in itself, the internal component in itself, was hampered the very second, minutes. And my knowledge was strictly confined to the fact that I am working on a screen. This is merely a screen, minutes. Secondly, minutes, let's understand one more thing. Minutes, the person showcasing me about everything is the deceased daughter in herself, minutes, who knows about everything, every consequence, has a 2-week training on the specific device, minutes. And as your lordships pointed out rightly about the 15 years of experience, minutes, the 15 years of experience are about screens, minutes, are about basic electronics, not with the rarity devices, minutes, like this. However, the requisite knowledge with regards to the device was still only and only with the complainant, minutes. Even after having such knowledge, she trusted me with hope, minutes. She came in front of me, minutes. Let's look at it in a very humanitarian lens, minutes. The clock is ticking, her father is dying, minutes. She has exhausted all her alternatives. It appears to me that she has alternatively exhausted all her alternatives, my lords. She calls her brother to get the backup transmitter, which is not possible at the moment, my lords. What am I being showcased, my lords? I am being showcased that she is out of options. I have to help her, my lords.
Did you tell her that you have no knowledge of this product? Your good faith, did you tell her? And then did she tell you that I understand you don't have knowledge, but please proceed to do it because this is our last resort?
Let's to answer your lordship's question, we need to again study the chronology of facts. The fact is that the complainant, when came to me, I did my due diligence, my lords. I tried to look for this device's blueprint, my lords. I precisely studied the device. I asked what is this device, my lords? I asked multiple times, what is this device? She explained it to me, my lords. However, my lords, it is her in para 15 where she explicitly states that this is a screen issue. You please fix the screen issue. That the screen broke down. So, my lords, when the complainant herself says that yes, this is a screen issue, I confided myself to screen, my lords. Only screen. That's all, my lords. Now, coming on my act, my lords. Knowledge of my act. Malas, I'm squarely covered under a not so gloomy work of words, but constantly employed by Honorable Courts of India, the Good Samaritan law, Malas. Malas, the Good Samaritan law where a person intends or have knowledge that the act might be a little dangerous, but it is to be done to prevent a greater peril, Malas. That is where Good Samaritan law comes in work, Malas. Malas, the Honorable Bombay High Court in Chacha versus State of Maharashtra employed the very same doctrine in deferring the culpability under 304 part 2, which is resonance with 105 PNS. And your lordship, the facts are of utmost importance. In that particular case, death was not foreseeable. Death was way behind, no one could anticipate that it would lead into death. However, this person who is accused in the case, took a lathi and made a blow on a husband who was drunk and who was verbally abusing her wife. Just to prevent a greater peril, he foresees the act of when the verbal abuse will turn into a physical abuse. Now, this anticipation in itself is such big, but however, the Honorable Bombay High Court acquitted completely exonerated. Now, let's understand two more things, I understand that your lordships might think that Isabella telling me, showing me manuals might be my knowledge that this act would likely to cause death, but this is not the case. Let's understand that knowledge is something personal to someone, It is subjective. It comes in personal realm, Someone inducing their information, someone inducing hearsay on me cannot be attributed as my personal knowledge, And that is not what the council is saying, This is what Black's law says, A personal knowledge cannot be someone else's information or hearsay, So, now, if your lordships today at all decide to convict the accused, in the present case, it would reckon the criminal jurisprudence at all, And why is that? Because every rescuer would be hesitant, would be hesitant to rescue or help, And why is that, Because there is a risk of going to jail, There is a risk of being prosecuted, Inferring knowledge to prevent death into a knowledge to cause death cannot be right, It's unjust. If your lordships have any questions, the council here would want to answer them,
Example of a rescuer and all that. It's not a goods matter and all that.
See, you should have.
Bystander is being asked to it. Your degree of knowledge is being input from your expertise. It's like somebody is being rescued by a bystander or a doctor.
Please, my lords.
If you go to a doctor who say you have a fracture and you go to a cardiologist,
Please, my lords.
the cardiologist looks at it and starts experimenting with the fracture.
Please, my lords.
That kind of a situation. You have a knowledge about the device,
Please, my lords.
Right? So there is a different standard
Please,
being
my
applied
lords.
to you and being also inferred because you have been given all those manuals.
Please, my lords.
So you are saying that, look, any rescuer, it's not an any rescuer. If I would have been asked to look at this device, I would have said, I have no knowledge about it. Please
Please,
take it to somebody else.
Please, my lords.
Or I would start opening it and say, look, it looks like a display device.
Please, my lords.
So it's not every rescuer will know that.
Let's understand the underlying principle behind this, my lords. The underlying principle behind all of this is prevention, my lords. Why is she showing me manual is not attributable to you? My lords, I humbly seek an extension of 1 minute to please.
Yes.
Thank you. Well, let's understand one thing. This woman showing me manual makes it even more my case, my lords. How I'll explain, my lords. This woman in itself has a 2-week training program. She had the manual. She knew the risks, my lords. Now she only coming for her father, my lords. For her own father. She's the one coming and saying, yes, I want the screen fixed. She herself voluntarily is getting into this act, my lords. So my knowledge was simply confined to the fact of the screen. So, my lords, the whole idea about this act was prevention and the knowledge was also prevention, my lords.
But you were told, that's where knowledge is being imputed to you. You were told that please just look at the screen, address the issue of the screen, don't go any deeper.
Please, my lords.
But you did, without seeking consent.
Certainly not, my lords.
So you knew that you were fiddling with a device of which you had no deep knowledge. You only repaired screens, and now you were looking into a very specialized medical device, which, as you yourself said, was something which was still under trial. It wasn't even a well-known and fully tested and tried device. Why did you take that risk?
My lords, I humbly seek to differ from the point of view raised by a lordship. The answer lies in the whole circumstances, my lords, whole facts. The facts are of such a nature, my lords. The time is of utmost essence in this present matter, my lords. The time is running. This person is on borrowed time. She has showcased me the very fact that there are no other alternatives left with her, my lords. There are no other alternatives left with her. This has been showcased to me, my lords. I am her last hope, my lords. I am merely intervening as an humanitarian grounds, my lords. I look at it a very humanly lens, my lords. This is all, my lords.
All right.
My lords, now my co-counsel will be addressing issues number 3 and issue 4 with regards to causation as well as journal exceptions. Please, my lords.
Yes. Yes.
Your Lordships, criminal law does not move from death to guilt merely based on sympathy or instinct. Your Lordships, it moves in this manner based only and only upon the foundation, a twin foundation, Your Lordships, being firstly the mental element as addressed by co-counsel, and secondly, Your Lordships, what remains is the actus reus. Now, Your Lordships, counsel will be addressing the actus reus terms in terms of causation. And Your Lordships may note that there are 2 key layers within causation. Your Lordships, there is causation in fact, and thereafter there is causation in law. Now this honorable bench may note that the difficulty in the prosecution's case today, Your Lordships, is quite simple. They fail at both of these layers of causation and then they plead. Your Lordships, they plead for this honorable bench to infer criminal liability based on a tragedy alone. Your Lordships, the offence at hand in front of this honorable bench today is that of culpable homicide not amounting to murder. Your Lordships, this offence is a consequence-based crime, which means, Your Lordships, not only must there be an act done by the accused, but the same act, Your Lordships, must also be the cause of death. Thereafter, Your Lordships, counsel would like to contend the fact that had it been a case of a simple and linear chain of causation, for instance, your lordships, let's assume there is person A and person B. Now, your lordships, person A has a device. This device is identical to the device of Mr. Anthony. Thereafter, your lordships, person B either accidentally pushes Mr. A, knowing that it will break the device, and thereafter, your lordships, Mr. A dies. It would then flow quite naturally from this honorable bench that it is indeed person B who caused the death of Mr. A. Unfortunately, your lordships, the present case at hand is far from such simplicity. Your lordships, the present case at hand has not one, but multiple circumstances that are operating together in the chain of causation. Thereafter, your lordships, counsel would first like to place reliance on the but-for test which was given in the case of R versus White. Your lordships, in the but-for test, the honorable bench was presented with a case wherein there was a mother and a son. The son had poisoned his own mother. However, your lordships, in that case, the mother had also suffered from a heart attack. Thereafter, the question before the honorable bench was quite simple. Would the death of the mother, your lordships, have occurred but for the act of the accused? Your lordships, whether it was the heart attack or the poison that was given by the accused in that case that caused the death of the mother, therein, your lordships, the honorable bench evolved this test. Now, your lordships, this test also goes for the legal maxim that is applied by the Honorable Supreme Court of India, which is causa sine qua non, which is, your lordships, that a cause must be the necessary cause for the outcome in a particular case. Now, your lordships, let's tie this to the factual matrix at hand. Your lordships, Mr. Anthony and Miss Isabella travelled without a backup transmitter. They travelled, your lordships, beyond reachable distance. And your lordships, they travelled during peak traffic hours. Thereafter, your lordships, the accused did not ask them to put themselves in a situation. The accused was not even the one that broke the device in the first place. Your lordships, it was indeed Mr. Anthony who was in the mall, who tripped on the stairs, and due to which the device display screen broke and the device display became unresponsive. Now, thereafter, your lordships, Mr. Anthony and Miss Isabella did approach the accused, Mr. Lucio, whereupon, your lordships, Mr. Lucio did indeed attempt a repair on the device. Now, your lordships may note the factual matrix quotes the word during the repair, a short circuit was witnessed. It occurred, your lordships. Nowhere in the proposition, your lordships, does it say that the short circuit was caused. Now, your lordships may also refer to paragraph number 22, your lordships, which is stated on page number 6. Page number 6, paragraph number 22. Therein, are your lordships with me?
Yes.
Therein, your lordships will notice the word soon thereafter. Now, your lordships, this is of utmost importance because it is to be read with the safety net timeline. Your lordships, the very company that made this peculiar device, this unique device, your lordship, states as a matter of fact of a guarantee and the only medical opinion in the present case that the timeline of the safety net is 60 minutes, which means, your lordships, that there must be a lapse of these 60 minutes before any symptoms of cardiac arrest start showing in Mr. Anthony. Now, your lordships, it is impossible to ascertain whether it was indeed the short circuit that caused the particular failure of heart of Mr. Anthony. Furthermore, your lordships, counsel pleads for this honorable bench's patience in a particular argument which will be made by counsel. Your lordships, there is something known as a latent defect. Your lordships, by the very meaning of latent means something which is hidden. Now, your lordships, when a device has fallen to the floor, it has cracked severely in such a manner that the display screen is being unresponsive. And as co-counsel has also pointed out, as per the proposition, your lordships, any malfunction can cause two symptoms of cardiac distress and eventually lead to a cardiac arrest. Now, your lordships, is it not possible that prior to the accused even entering the picture, either due to the fall of the device or the malfunction due to which the display was unresponsive in the first place, that the device, your lordships, admittedly, it is possible that the device was not dead entirely, because as the contentions of the accused as well, the accused says that the accused will fix it without shutting it down for longer than 30 minutes. Therein, your lordships, is an implication that the device was not dead entirely. However, your lordships, what counsel is trying to contend is, can this honorable bench conclude with utmost certainty that the device was still fully functional? Your lordships, we are indeed talking about a device which is responsible for sending AI signals to a heart. Your lordships, is it not at all possible that pursuant to any malfunction prior to even the entry of the accused in the present case, that the device was not already in a state of malfunction? Your lordships, in the present case, we have an absolute absence of any evidence supporting the prosecution's case and establishing the same beyond reasonable doubt. Thereafter, your lordships, the counsel would also like to cite the case of Rajiv Singh versus State of Bihar, wherein the Honorable Supreme Court clearly states, your lordships, suspicion, however grave it may be, can never replace proof. And your lordships, it is specifically stating that in cases similar to the one at hand, where the situations and circumstances are formed in such a way that causation cannot be linear and it leaves room for reasonable doubt, your lordships may note that the benefit of such reasonable doubt, your lordships, is to be given to the accused and not to the prosecution. Moving further, your lordships, counsel will also state one last limb for causation. Your lordships, counsel has addressed the but-for test in light of causa sine qua non. However, your lordships, this test has now become outdated, which the Supreme Court has stated in the case of Sushil Ansal versus CBI. Therein, your lordships, the Supreme Court has went one step further than mere necessity. Your lordships, the Supreme Court has stated that a cause must not only be necessary for the outcome, but it also must be causa causans, which is, your lordships, it may be proximate, it must be direct, and it must be the last link which makes the death of the particular deceased inevitable. Your lordships, the accused may very well have entered the scene subsequently to the death already being in place, your lordships. The time clock of the death could very well already have been started, your lordships. Furthermore, your lordships, to assist this honorable bench in simplifying this particular inquiry at hand, counsel proposes what is known as the nest test. Your lordships, in the nest test, counsel would plead this honorable bench to indulge in a two-step inquiry. In the first step, your lordships may ascertain whether there existed, your lordships, a set of conditions which were together sufficient to cause death. In the present case, your lordship, this includes the falling of the device, the absence of the backup transmitter, as well as the actions of the accused. However, in the second step of the same, your lordships, the honorable bench must ascertain whether the act of the accused, your lordships, was the substantive and the operative final link of the present case, your lordships, that must be proven beyond reasonable doubt to be the final action, your lordships, that caused the death of the accused. If your lordships have any questions, counsel would be much obliged to answer the same.
Madam, my only concern is that your client admittedly was not well versed with the device. Why did he not decline to operate on it? And his action of proceeding, why does it not show lack of good faith?
Please, your ladyship. Your ladyship may refer to paragraph number 6 of the Moot proposition on page number 4 for your lordships. Page number 4, para number 6. Your lordships, therein, the prosecution today has painted a picture for this honorable bench, your lordships, as if the device is truly inscrutinable. The device is something exotic, your lordships. However, they have made a very simple confusion. Your lordships, the device in the present case, which is indeed unique, is the Atria Link system, which is embedded in the heart of Mr. Anthony. Your lordships, the second device, which may indeed be unique, is the software application, your lordships, which is said to be peculiar. However, your lordships, what is not unique in nature, and the proposition itself has stated nothing to the effect other than the mere fact that it is a mobile-based transmitter, your lordships, is the very device that the accused attempted to repair. To answer your ladyship's question even further, your ladyship may note that the act of the accused cannot be read in the absence of the knowledge of the accused. Your ladyship may note that in presence of the fact that it was indeed a mobile-based transmitter and the accused did indeed possess experience in dealing with electronics generally, your ladyship, it was very much the belief and the knowledge of the accused that he would indeed be able to fix the device. Furthermore, your ladyship, even the request made by Miss Isabella was restricted to repairing merely the screen and display of the device. If there's any other questions by this honorable bench, counsel.
Madam, in your experience on the basis of law, when a person does something when an expert is approached to repair an instrument with the knowledge that it could lead to the death of the person, would merely the fact that he's a good Samaritan be enough, and it would meet the test of good faith if he is not an expert?
Your ladyship may note the fact that your ladyship has used the words the accused was aware that his act would likely to cause death.
Isabella had warned him that it would lead to.
Indeed.
So he was sufficiently warned in the opinion of the court.
Indeed. Indeed, your ladyship, however, your ladyship must read the context of the knowledge of the accused to ascertain the answer for the same. Your ladyship, knowledge must be read in consonance with the act, but also must be read with the consonance of likelihood. Your ladyship, in the offence of culpable homicide not amounting to murder, the threshold of likelihood in the knowledge that my act would be likely to cause death of another person, your ladyship, is quite high. Here in your ladyship, when the device short-circuited, when the device stopped working, the accused was visibly shocked, your ladyship. The accused clearly did not expect that same to happen. Therefore, your ladyship, the very threshold of likelihood that is attached to be attached as an essential for the offence at hand itself remains unsatisfied. Furthermore, your ladyship, addressing another anticipated concern of this honorable bench today, pursuant to the exhibit, this honorable bench, your lordships, may note that in the exhibit present in the proposition, there is a warning which was also referred to by the prosecution in the present case. Your lordships, in the warning there's a heart symbol and it is mentioned, do not open or interfere with the internal components. Counsel will argue, your lordships, that the prosecution has conveniently managed to read only the first half of the warning. If counsel is to read out your lordships may refer to page number 15 for your lordships. If counsel may read out the remaining aspects, it talks about the physical integrity. Your lordships, the reason why the device should not be opened and the internal components must not be interfered with is the integrity of the device, which is what is crucial for the heart pacing. Your lordships may note in the present case, the integrity of the device, your lordships, was already a gone fact. In fact, your lordships, the accused was not trying to worsen the integrity but restore it. Your lordships, the device had fallen and it had been severely damaged to an extent where the display was completely unresponsive. This in itself, in absence of any exhaustive list of what malfunctions are there or what, your lordships, can be another damage to the device, this very well can constitute certain damage to the integrity of the device itself. Your lordships, this does not go to say that the accused ignored this particular warning, but rather that the accused diligently paid heed to this very warning in his attempt to repair, to restore this very integrity. If your lordships are satisfied with respect to the causation argument, counsel would like to move on to the last limb of counsel argument with respect to general exceptions. Your lordships, in event that the prosecution has successfully established the essentials of the particular offence at hand to this honorable bench today, counsel would argue that the acts of the accused in the present case have been fairly covered under general exceptions, namely, your lordships, section 19 and section 26 of the BNS. Your lordships, the same address the part of consent by the complainant and the person suffering harm, as well as, your lordships, the fact that the act of the accused was to avoid a greater peril or a greater harm in the present case. Your lordships, it may be noted that in both of the particular sections, the accompanying factor is also good faith. Your lordships, the prosecution has contended that the good faith and due care that was practiced by the accused was merely of the general category, the general precautions that he would have undertaken for any other device. However, your lordships may note that nothing in the proposition states that wearing static gloves or rubber-tipped tweezers include a general level of precaution as opposed to an extraordinary one. Furthermore, your lordships, due care and caution are the most used words of the proposition itself. Your lordships, in every other paragraph of the proposition, it is highlighted time and time again that a single move of the accused, not a single move of the accused, your lordships, was done without due care and caution. Your lordships, this goes to say that good faith in the present case is not even in question. Moving on to consent, your lordships, the prosecution had contended that the consent in the present case was conditional. Being, your lordships, that Miss Isabella had only consented requisite to the fact that the accused does not meddle with internal components or open the device and operates with due care. Again, your lordships, let's understand what Miss Isabella truly consented to. Your lordships, Miss Isabella had consented to repairing the display of the device. Your lordships, thereafter, the accused in the present case, Mr. Lucio, identified the part of the display that was not working, which is the dislodged display, your lordships. Thereafter, the accused, on purpose and with utmost caution, while avoiding it touching any other internal component, focused only and only on the display. Furthermore, your lordships, even going back to the warning, he was merely trying to restore that very physical integrity, your lordships. Therefore, the consent given by Miss Isabella cannot possibly be said to be vitiated. Your lordships, lastly, it cannot be countered that the acts of the accused were clearly to avoid a greater harm in the present case. Your lordships, in the facts of the present case, it is truly established that if anything were to go wrong with the device, that Mr. Anthony would start facing cardiac arrest, or at the very least, your lordships, harm to his heart. It may be noted, your lordships, that the harm that is to be avoided is not even restricted to death. It can be any greater harm, your lordships. Furthermore, your lordships, the harm would be suffered by a person who has already suffered 2 cardiac arrests in the past. Thereafter, your lordships, the risk that was undertaken by the accused in a belief that he was a person who would be able to deal with the device in light of the fact that it was merely a mobile transmitter, in light of the fact that the very daughter of the aggrieved, of the person who had this device embedded in him, was the very person who pleaded to the accused to beg for his assistance, your lordships. It cannot be stated at all that the accused should be held liable for the offense of culpable homicide not amounting to murder. Your lordships, if this conviction is upheld, this honorable court risks jailing a person who is inherently innocent. Thereafter, your lordships, if the honorable bench does not have any further questions.
Madam, you produced the defense witness number 1.
Yes.
Have you seen his statement in examination in chief at para 7?
Indeed.
And the cross-examination at para 16?
Indeed, your
Is
ladyship.
it correct that the accused represented that he would not touch any core component while undertaking the repair?
Indeed.
And is it the opinion of your witness that this board was indeed a core component?
No, your ladyship.
Para 16, page 21.
Indeed, indeed.
Yes.
Your ladyship, therein a distinction must be drawn. Your ladyship, the circuit board in itself is admittedly an internal component.
Yes.
However, your ladyship, the dislodged display is not an internal component. Your ladyship may refer to clarification number 41 for the same, which is, your ladyship, located on page number 30 for your lordships.
Yes.
Page number 30, clarification number 41. Your ladyship, it blatantly asks whether the dislodged display connector and the cable were the same component. And the second half of the question asks whether this is an internal component. Your ladyship, the only question that was answered within that clarification is that they're indeed the same component. However, neither of them can be said to definitively be a part of the internal circuit component. And your ladyship, there's nothing in the facts to state that the dislodged display was a part of the circuit board, even if the circuit board is established to be an internal component. Counsel hopes that satisfies your ladyship's question.
Okay.
Indeed. Your lordships, if there's nothing else from this honorable bench, counsel would like to conclude counsel's arguments. It was truly a pleasure arguing before this honorable bench today. Much obliged.
Thank you.
I think we're done.
All right.
This very fact that the counsel acknowledged and that the death of the deceased was in any which way granted inevitable is what the counsel shall firstly contradict. To this matter, it is firstly pertinent to note, Your Honours, that my learned friend makes a very contradictory argument. They firstly claim that this so-called display connector does not constitute an internal component, and on the very other hand, also contend that its fall or its dislodgement is causative of death of the deceased, and that the time from which his death was already spanned had already begun before the accused had access to the transmitter. Now, these are two very contradictory submissions, Your Honours. Either this display connector was an internal component or it was not. These two cannot suffice together, Your Honours. On the same line, Your Honours, this argument that the knowledge was not possessed on part if the accused shall also fail. Now, why the counsel says so is because the contention has arisen that the knowledge that Isabella had cannot be imputed upon the accused. However, the submission of the counsel at this juncture shall be that the same shall be imputed because the warnings regarding the use of the transmitter, its handling, and explicit directions to not interfere with internal components were at least provided. But now at this juncture, when he attempts to find the schematics of the device and then fails to find them, and then even thinks that yes, I should proceed with the device that I am completely unfamiliar with, have never experimented upon, and still proceeds to make an intervention against the directions provided to him, is not an act out of necessity, Your Honours. It is instead an act which is derived from the conscious awareness that consequences shall ensue of death from this very act, Your Honours. And therefore it was not one which was undertaken with the good faith, as has been argued, Your Honours. Additionally, when this motive, Your Honours, is to be considered, it is not relevant when knowledge has been clearly established, as has also been laid down in the case of R versus Latimer, Your Honours. Good Samaritanship does not arise from having the knowledge that the necessary consequence of death shall ensue in this matter, Your Honours. And therefore, the knowledge upon the accused was of a very, just last submission that the counsel should make, Your Honours. Your Honours, therefore, the standard of care that was implied upon the accused was not one which shall be seen from the lens of Isabella, that she failed to carry a transmitter, or that she did not object, Your Honours. It is rather to be seen from the lens of this very technician, who claims to be of an experience of 15 years, and yet proceeds with a completely unfamiliar device at this juncture, Your Honours. And therefore, Your Honours, an additional fact that the counsel shall make is that the court has been misdirected on several facts. Firstly, that it has been provided that this transmitter was a normal mobile related transmitter. However, if Your Honours may kindly refer to page number 18 to you, Your Honours. Paragraph 14 of the same page. If Your Honours are with me. Your Honours, there are Isabella providing the accused that this transmitter was not an ordinary mobile transmitter. It was critical to the life of the deceased. Your Honours, this very fact lays down that it did not resemble to any other devices that the accused had prior experience in. The claim that this transmitter was an ordinary mobile transmitter and that interference with it shall be made is a false claim made on part of the counsel, Your Honours. Additionally, it is also admitted by them, Your Honours, that this time lapse was there between the short circuit and the occurrence of symptoms of cardiac distress. This is also a false claim, Your Honours. If you may kindly refer to page number 18, Your Honours, paragraph 20. It provides, Your Honours, if you are with me, that, Your Honours, within minutes, after the short circuit, the disease began exhibiting symptoms of cardiac distress. There was no break in the chain of causation. It has been very simple, and the causal chain has been established in this very aspect, Your Honours, that it was a very immediate occurrence. Death of the deceased was immediately post the short circuit had occurred on part of the accused. And finally, Your Honours, however so it may be contended that the short circuit is not something which is caused. Your Honours, it will not ever be blatantly laid down that the term caused or the term triggered by on part of the accused will be ever provided in the facts. What needs to be understood is that when the cumulative appreciation of circumstances is made, whether the clear occurrence of an act is a result of any violation made or is a result of any act undertaken which was not supposed to be done. And that shall be my submission, Your Honours.
The knowledge was that if he did not repair the device, Anthony would die. That was the knowledge. So the knowledge of the act was repairing the device. To say he should have stuck only to repairing the display and not open the device, etc., would have been an incomplete act. So the knowledge that you can attribute to him is that if you don't repair this device, my father will die. He was trying to repair the device.
I understand the concern, but Your Honor, that would have been the case.
Knowledge of the act.
Yes, Your Honor.
That if this act is done, this man will die.
Certainly, Your Honor.
This man suffers from cirrhosis of the liver.
Right.
If I kick him in his liver, he might die.
Certainly.
And you kick him in the liver. That's the act. Here, that's not the act at all. The act was what you asked him to do, namely repair.
Your Honor, that is the exact submission of the counsel. That when the accused is himself saying that the transmitter is functional, simply the display is interfered with, then you know.
Then you would never have gone to him.
Your Honor, that is the another submission of the counsel, that it was the mere assessment of risk.
Absent a functional display, you did not know what was wrong with the device. So
Certainly.
therefore, it was important for you to get the display to function.
Certainly, Your Honors.
He was trying to repair the device.
And that is what the
Get it
accused
functional.
himself admits, Your Honors, that the display was limited, that the display issue was the sole issue to the transmitter. The transmitter was functional in all the other aspects, Your Honors. And then what exactly after this inspection warrants interference with internal components is the question of the counsel, Your Honors. When the issue himself has been admitted to be just display, Your Honors, upon his inspection of himself.
All right.
Much obliged, Your Honors.
Thank you. Yeah. Arguments heard, judgment reserved. We'll see you. We'll see you 3 months later. Okay, just some thoughts that I would like to share. And this is not just for this moot, but I have noticed this in some other moots also that I happen to have judged. First and foremost, as I said to you, you have to carry the court with you. So you have to be on the same page, same para as the judge. Now, a lot of time goes in you saying something and we actually understanding what you're saying. The idea is the communication. Taking cue from the same thing, a rote recitation is not a good idea. So you have to make submissions there and then. It has to be the here and now of an argument. And that argument therefore has to proceed both with communicating, with eye contact, with body language. I don't fault you at all for not knowing all of that, because all that comes only when you practice in a court. But that's the destination, that you have to actually relate to the court, to the judge and all of that. I must commend you for the manner in which most of you fielded the questions and you're thinking on the feet, which is exactly what counsel need to have to be able to answer the question and turn the argument around and all of that. So I'm very impressed with the performance of all of you. But it requires that more being present in the moment kind of thing. That sounds a little philosophical, but counsel do that all the time. And that's what counts ultimately. So that's as far as I'm concerned.
Yeah, so I think both the teams performed very well. And your narrative was, both of you teams had a good narrative, which was easy to grasp and easy to understand. And I like the fact that that you didn't drown us with the rulings, the case law, which normally in the court experience is different. So I always say that, and I think I read there somewhere that rulings are like torches. They're not crutches. So you use them to expose for the exposition of a principle of law, and that's about it. Don't go into the paragraphs, go into the ratio of those. In responses, as Justice Bambani also mentioned, your responses were measured. The tone should be very measured, always, and not sharp. These questions from the bench only help you to be precise. Take all questions from the bench whenever you become lawyers and you practice in the court as an indication as what the bench is looking from a counsel. Here also, you fielded the questions with poise, with calmness, and so I really like that part. And I scribbled something for you that yeah. So the facts always, to my mind, in criminal law, are not the background. These are that's the battlefield. That's not the background. So stick on the facts. From the facts will be the conclusions. Like in this proposition, we were focusing on the knowledge. The knowledge is a conclusion to be drawn from the conduct, which is derived from the facts. So good work, both of you, both the teams. Thank you.
I'll just I'll just add one sentence. I think given the botched up prosecution investigation, you fought valiantly. And I think the defense did not take enough advantage of the botched up investigation. And I think that is what Justice Narula was trying to say, that as a part of the moot court, you can also take advantage of the lacuna of facts and not just, and of course, if facts are in your favor. But I think it was a tremendous job. I couldn't have done half of the good work both the teams have done. So all the very best to all of you.
I'll just add one more thing, especially in relation to a criminal matter. And I've said this in some of the events that I've attended at law schools and all that. Storytelling is a big art. Storytelling and even theater, drama in a court is a very big art. So a matter like this, which involves somebody dying and somebody's mistake, oh my God, this should have happened, that whole narrative can also be built. So storytelling is a big skill set that you need to hone, especially as criminal lawyers.
Concrete indicator.
From what you said, everything turns on the facts. Thank you.
Thank you.
Thank you. See, I haven't looked and all that, but clearly I found the defense team was very strong.
Speaker one, na? You just last me speak here. The girl who spoke in the last.
No, even the boy.
I just request everybody to be seated in the audience, please. Please do not step out. Requesting everybody to be seated. Starting with the prize distribution in about 10 minutes.
पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल
This evening celebrates those who stayed the course, weathered the storm, and proved that the going gets tough, the tough truly get going. A very resilient and resonant good evening and a warm welcome to all the prodigious people present in this august gathering. I heartily welcome you all to the prize distribution ceremony of the 22nd KK Luthra Memorial Moot Court 2026, organized by the Moot Court Society of Campus Law Center, Faculty of Law, University of Delhi, in association with Nirmal Luthra Foundation.
A special welcome to our chief guest for the day, Honorable Mrs. Justice B.V. Nagaratna, Judge, Supreme Court of India, and guests of honor, Honorable Mr. Justice Anup Jairam Bhambani, Honorable Mr. Justice Sanjeev Narula, and Honorable Mrs. Justice Manmeet Preetham Singh Arora, Judges, High Court of Delhi. Now, without further ado, I request the Professor in charge of Campus Law Center, Professor Dr. Gunjan Gupta ma'am, to come to the podium and deliver the welcome address.
A very good afternoon to all present here. Honorable Mrs. Justice B.V. Nagaratna, Judge, Supreme Court of India, Honorable Mr. Justice Anup Jairam Bhambani, Judge, High Court of Delhi, Honorable Mr. Justice Sanjeev Narula, Judge, High Court of Delhi, Honorable Mrs. Justice Manmeet Preetham Singh Arora, Judge, High Court of Delhi, members of the Luthra family, Mr. Siddharth Luthra, Mrs. Ketki Goswami, Dr. Meera Luthra, Mrs. Geeta Luthra, esteemed dignitaries, respected faculty members, senior professors, Professor Rajiv Khanna, Professor T.D. Sethi, and dear participants. It really gives me an immense pleasure and pride and exhilaration to welcome you all to the prize distribution ceremony of the 22nd KK Luthra 2026. A tournament where dedication meets the distinction and perseverance finds its rightful place. Today, we do not merely distribute prizes. We celebrate the journey of growth. Incorporated in the legal maxim, actus non fecit, reum nisi mens sit rea, and taught in our classrooms and courtrooms alike. It is indeed an intent coupled with action that shapes true excellence. Over the course of this league, we have witnessed minds sharpened like well-honed arguments and teams rising step by step, proving that the seeds of discipline sown in effort blossom into the laurels of success. As the professor in charge of Campus Law Center, I stand before you not just to felicitate the achievers, but to acknowledge the spirit that dared to aim high, push boundaries, and turn potential into performance. Our chief guest, Honorable Justice B.V. Nagaratna, Judge, Supreme Court of India, has kindly accepted our invitation to grace this event. Welcome you, ma'am. Madam exemplifies an intellectual rigor, constitutional fidelity, and a deep commitment to justice. Before advancing as a judge, ma'am devoted 21 years of advocacy with a remarkable diverse practice spanning constitutional, administrative, commercial, service, family, insurance, land laws, as well as arbitration and conciliation. The list was too long, ma'am. After becoming a judge in the Karnataka High Court and later on in the Supreme Court of India, she has consistently underlined the centrality of the constitutional values, institutional integrity, and citizen-centric governance. Being a part of several landmark decisions, leaving an indelible imprint on the Indian legal system. We really welcome ma'am. A huge round of applause for ma'am. I would further add her most notable judgments include Bilkis Yaqub Rasool versus Union of India in 2024, where she set aside the remission granted to convicts in Bilkis Bano case. In Neeraj Datta versus Government of NCT Delhi in 2023, clarifying the evidentiary standards under the Prevention of Corruption Act. In Kaushal Kishore versus State of Uttar Pradesh in 2023, addressing the contours of free speech under Article 19 Clause 2, and in her principled dissent in Vivek Narayan Sharma versus Union of India in 2023 concerning demonetization. I really heartily welcome ma'am for this prize distribution ceremony of the 22nd Luthra Memorial Moot Court 2026. We also have with us Honorable Justice Anup Jairam Bhambani, Judge Delhi High Court. After setting his independent chambers in 1994, Sir developed a substantial and a diverse practice before the Supreme Court of India. The Delhi High Court and other high courts across the country with particular expertise in media law, criminal law, constitutional law, regulatory jurisprudence. His appearances spanned issues of civil and criminal defamation, privacy, free speech, media and telecom regulation, contempt, juvenile justice, death penalty, narcotics, copyright, parliamentary privilege, and commercial disputes. Sir was designated as a senior advocate in 2014 and later on was appointed as a judge of Delhi High Court in 2018. He was also rendered significant service in the field of legal aid and public interest, assisting courts as amicus curiae in matters that shape procedural frameworks for victim compensation, accident claims, juvenile justice reforms, labor rights, and under urban governance, reflecting career anchored not only in the doctrinal excellence, but in tangible access to justice. We welcome you, sir. We also have with us Honorable Justice Sanjeev Narula, Judge High Court of Delhi, whose professional trajectory reflects a rare confluence of technological insight and legal acumen. His extensive litigation portfolio spanned civil, commercial, and corporate disputes, custom, indirect taxes and GST, service and constitutional law, banking and finance, land and property, arbitration, intellectual property, cyber and e-commerce law, consumer and family law. He served with distinction as Central Government Standing Counsel, Senior Standing Counsel, Customs and Indirect Taxes, and Standing Counsel for the Central Information Commission before the Delhi High Court, until his elevation as a permanent judge of the Delhi High Court in 2018. After becoming a judge, Sir has appeared as a key judicial voice in matters traversing commercial law, taxation, constitutional adjudication, and the rapidly evolving domain of technology law. I really welcome you, sir. A huge round of applause for him. We also have here with us Honorable Justice Manmeet Preetham Singh Arora, Judge High Court of Delhi. Over 25 years of practice, her practice is concentrated on civil and commercial disputes, company law, arbitration, administrative law, with significant experience on the original side of the High Court. She was frequently appointed by the Delhi High Court as sole arbitrator, amicus curiae, and court commissioner. Elevated as a permanent judge of the Delhi High Court in 2022, Her Ladyship brings to the bench deep expertise in commercial jurisprudence and a nuanced understanding of complex civil litigation. So I welcome you, ma'am. An event of this magnitude requires a support and cooperation which we are lucky to receive in the form of endowment and trust from the Luthra family. I am very grateful to all the relatives and friends of the Luthra family who have always graced this event and made it even more august with their presence. Hosted annually by the Campus Law Center in collaboration with the Nirmal Luthra Foundation, established in affectionate remembrance of late Shrimati Nirmal Luthra ji, beloved wife of late Shri K.K. Luthra ji. This memorial moot court stands as a tribute to a life of generosity and legacy. The K.K. Luthra Memorial Moot Court commemorates Shri K.K. Luthra, a cherished alumnus of Campus Law Center, whose enduring spirit of giving continues to inspire this institution. Carrying forward that legacy, that Nirmal Luthra Foundation has this year generously donated 29 laptops to the visually challenged students of Campus Law Center Faculty of Law. I also welcome at the same time and really thank all the participating teams consisting of 216 participants from 10 different countries who have traveled across the globe to participate in this illustrious event. We had started the tournament with just 18 teams in the first edition of the event, and now see, we have grown to 72 national as well as international teams. I really thank each of the participating teams for participating in the event, making it a huge success. I really congratulate the winners on their success as they would be announced shortly, but would like to add that for me, each of the teams that participated are winners, as all of you are going back with experience which will surely help you in your future endeavors. We got to witness extremely engaging and thought-provoking argumentation and courtroom exchanges over the course of past 3 days. I'm elated to share that with the smooth functioning of the 5 layers of rigorous adjudication, enthusiastic participation of the teams, and tireless hard work of the organizing committee, the whole tournament was a huge success, and this could not have been possible without the relentless efforts of my dear colleague, the convener of Moot Court Society, Dr. Rubina, convener, Moot Court Society. Dr. Rubina, I would like you to show yourself. Yes, Dr. Rubina. And along with her, I would fail, her committee comprising of 10 members. All those 10 faces, I would like to just raise your hands. A huge round of applause. Also, the acknowledgements are due to the whole student organizing committee of the Moot Court Society of CLC, consisting of 25 members and their student convener, Mr. Ayush Rana. Ayush, I want you to just show your face properly. The successful execution of this event stands as a testament to the valuable contribution of, the figure is too much, I would say, it's over 300 plus dedicated volunteers whose tireless efforts, commitment, and meticulous coordination have ensured its seamless conduct. These organizing committee members, really have burnt the candle at both ends to bring this event to a glorious culmination. So, ladies and gentlemen, a very, very big hand for all the ones, for the participants. Thank you so much, everyone.
Thank you so much, ma'am, for your motivating words. Now, I would like to request Dr. Meera Luthra, ma'am, to come up the dais and felicitate our chief guest of the day, Honorable Mrs. Justice P.V. Nagaratna, with a token of our appreciation and gratitude. A huge round of applause. Thank you so much, ma'am. Now, I request Mrs. Geeta Luthra, Senior Advocate, to ascend the stage and felicitate Honorable Mr. Justice Anup Jairam Bhambani. A huge round of applause for sir. Thank you so very much, ma'am. Now, I request Mrs. Ketki Goswami, Advocate, to come up the dais and felicitate Honorable Mr. Justice Sanjeev Narula. A huge round of applause for sir. Thank you so much, ma'am. Now, I would like to request Dr. Rubina Grewal, ma'am, the convener of the Moot Court Society, to ascend the stage and felicitate Honorable Mrs. Justice Manmeet Preetham Singh Arora. Thank you so much, ma'am. Now, I would like to request Mr. Soham Krishan Luthra, Advocate, to come up on stage and felicitate Professor Dr. Gunjan Gupta, ma'am. A huge round of applause for ma'am.
I now request our chief guest of the day, Honorable Mrs. Justice B.V. Nagaratna, to approach the podium and enrich the audience with her thoughts. A huge round of applause for ma'am, ladies and gentlemen.
Namaskar and a very good evening to everybody. My esteemed brother and sister judges, Justices Anup Bhambani, Sanjeev Narula, and Manmeet Preetham Singh Arora, judges of the High Court of Delhi, Sri Siddharth Luthra, Ms. Geeta Luthra, Senior Advocates, and sponsors of the KK Luthra Memorial Moot Court Competition, and the entire Luthra family whom I got to meet today. Professor Dr. Gunjan Gupta, Professor in Charge, Campus Law Center, my alma mater. I may say one thing very frankly, that where our lecturers were very good, our foundations in that subject is good. But where they were ordinary, our foundations are very ordinary. Justice Amitav Roy, former Judge, Supreme Court of India, faculty members of the Campus Law Center, organizers of this moot court competition, participating teams, distinguished invitees, dear students, and members of the media. I am delighted to be here today to participate in the felicitation of the winners of the 22nd edition of the KK Luthra Memorial Moot Court Competition, held between 13th and 15th February 2026 and conducted by my alma mater, Campus Law Center. In fact, Mr. Luthra said that I should be here, last year I should have been here. But since it was not possible, the dates were not matching, he said advance booking by 1 year. And I've kept up my promise. Over the course of the past 2-3 days, 72 teams, 216 participants from law schools and universities around the globe have engaged in incisive arguments and deliberations over complex issues of criminal law. The importance of such an exercise cannot be overstated. In a rapidly changing and increasingly complex world that you are all set to enter as lawyers, dear students, mere academic knowledge of the law as learnt in the law schools is not sufficient or adequate for a legal profession. This gap is actively bridged by participation in activities such as moot court competitions, where students are given the opportunity to hone their critical thinking, reading, writing, and speaking abilities. The efforts of Srimati Nirmal Luthra Foundation and the Campus Law Center, University of Delhi, in organizing and administering this event must be appreciated in this regard. The munificence of the Luthra family is commendable indeed. This competition also serves as a commemoration of the legacy of late senior advocate Sri KK Luthra, a renowned practitioner of law for over 5 decades. His journey began from being born and raised in a village, Mian Chanu, in West Punjab, that is present-day Pakistan, to studying law during the turbulent times of partition and in the immediate aftermath of Indian independence. It is said that he had to choose between law and government service and ultimately chose the legal profession. He rose up in the ranks to become an illustrious practitioner of criminal law, which exemplifies the principle that with hard work, dedication, and sincerity, the practice of law will reward you, no matter your origin. As students, it is likely that you will come across periods of trials and tribulations that may make you second-guess yourselves about your choice of the law. Never regret it. In such moments, it is important to remember that even stalwarts such as Sri KK Luthra experienced challenges as he attempted to chart the course of his legal career. By being focused, disciplined, and staying true to your conscience, and remembering why you decided to choose the law amongst the many options available to you, dear students, you will be able to weather these challenging times and emerge successful. The topic for the moot court is criminal law subject, because this is a moot court with regard to a criminal law topic. The uniqueness of criminal law also lies in how it acts as the fulcrum, where the authority of the state may legitimately deprive one of their life and personal liberty. What is thus expected of a practitioner of criminal law is not merely legal ingenuity, an awareness of precedent and compelling strategies of advocacy, but also a sense of fairness, compassion, open-mindedness, and integrity. It is a duty, an act of service to choose to render one's time and abilities to the cause of defending those whom we call accused and whom we generally castigate. This is in furtherance of the principle that everyone deserves to be adequately defended prior to being convicted, regardless who they are and the perceived magnitude and morality of what they were accused of. While a moot court competition may formally have a certain set of winners among all participants, I am hopeful that all of you would still affirm that your mere participation in such an event is really and truly meaningful. As a law student, it is not uncommon to feel as if you're being consumed by the competition, as it feels like your peers are able to accomplish much more than you and seem to be progressing while you're still in a rut. While the proliferation of platforms like LinkedIn, where according to me, most of the things are exaggerations rather than the truth and reality, don't go by those, then it may feel like nothing that you do can ever measure up to the constant stream of announcements of accomplishments and availing of opportunities by others. What do you do in such times? It helps to remind yourself that progress is not linear and that some of the seemingly futile endeavors you engage in today, such as this moot court competition, may actually pay off in an unexpected way in the future. While all of you could not have been adjudged winners today, perhaps you are made aware of a legal principle or a judgment or a tactic in how you must present your arguments that clinches a case or forms the basis of an argument for a future case in a real court. More importantly, you would have met and developed friendship globally. Are you better informed? Were some pre-existing beliefs of yours changed? Were you able to present your arguments with slightly more confidence before even a hypothetical court? You would be able to realize where you stand in a few days' time. While all of us differ in our interests and our natural strengths and weaknesses, my own experience has taught me that excellence in advocacy and distinguishing yourself in what feels like an ocean of legal practitioners, all jostling and vying for the same things, is the ability to see setbacks as temporary, to always be thinking of your next step, but not being too ambitious, and to commit yourself to your practice with sincerity and integrity and not for money alone. The temptations are all over. The temptations are ever present. But I always say the shortest word in the English language is NO. The moment you are able to say NO to any temptation, you are on the right track, your mind is free, and you can do what you want according to your own decisions. Great lawyers are not born, but are forged through every exam they pass, moot court they may have participated in, and question they ask in a class. Later, through every appearance they make in court, every transaction they may assist with, and just every time they encounter a new idea or concept. They are distinguished by their patience, their response to losing a case, their ability to tolerate delays and inconveniences, and in their willingness to learn from their seniors and peers, and willingness to help someone junior to them. The senior-junior relationship, as it was there traditionally, it was it was like a parent and a child in the offices those days. Which chamber you came from, the moment you stated your senior's name, you got an added respect in the bar or even outside because the senior was so well known. I think that relationship is now becoming very diluted, and I don't know, I feel that it should be restored. And the relationship in the bar room between the seniors and the juniors must be restored and not limited to only briefing a senior. It must expand to a relationship where juniors ultimately graduate to seniorhood and the seniors mentor the juniors. So I must inform this audience that there must be an attempt made to restore that kind of relationship I think Mr. Luthra would agree with me that relationship is not limited to briefing a senior or to a senior in the office with whom you would practice for some time and then open your own office. We all refer to our seniors in our generation, whether they are alive or no more. We say senior. We never even say their name. My senior used to say this. My senior used to do this. I recall even in the court. That should be restored. Many of the legal luminaries that you all look up to with admiration today are distinguished, not merely by their skills, but a love for the law and a passion to know as much of the law as they possibly can. This need to keep learning in a particular salient is in the era of artificial intelligence now. As future lawyers, you are entering the legal profession at a time when artificial intelligence is freely available. You are fortunate in how perhaps a lot more clerical tasks can be automated now, and how many of your queries can be instantly answered. But I am very apprehensive of the misuse of this valuable tool of artificial intelligence. The other day on Friday, there was a young advocate who was arguing a case, and another young advocate on the opposite side pointed out, my lords, there is a quotation here in the grounds with regard to a judgment of the Supreme Court, which quotation is not finding a place in the judgment at all. There is a name of a case, if I remember correctly, it is Mercy versus Mankind. Such a judgment doesn't exist. It is quoted in the memorandum of grounds in the special petition. And one more thing she pointed out, and this was a revelation to us. Sometimes we don't read the grounds, so it's okay. We don't get carried away. We go to see the impugned order more often. I hope impugned orders are not going to be made through artificial intelligence in future. That is why the certified copy is very important now, not just the uploaded copy. See, the traditional things have their value. Why do we insist on a certified copy rather than an uploaded copy? Because it's authenticated. So therefore, these are the things I am telling the younger generation, because we will be weeding ourselves out as far as I am concerned in a year or two. But the younger generation and the judges of today and future have to see whether a citation is really a correct citation or it is a got up one. Where have we come to? A suppression, a false statement, a misstatement itself is enough to have an impression about an advocate from the bench. But if these are the things, then whom should we believe? Whom should the bench believe? And if the bench doesn't believe the bar, then whom else should it believe? Therefore, this note of caution, I am saying that we need artificial intelligence, but to the extent that is required. I always say natural human intelligence is always better to rely on than artificial intelligence. To know how to independently peruse a judgment, identify the law and cull out what it holds, and come to an independent conclusion as to its merits, without the assistance of artificial intelligence, will hold one in good stead. Also, it is useful to think about a case from the perspective of both sides and then from the perspective of your client. I am happy to observe that many of the participants in this competition are young women. As young women who are soon to be lawyers, you are likely to encounter distinct challenges in the profession. That is something we should be aware of. What does the individual do then if presented with such systemic challenges? For example, I may say if a even a woman advocate is arguing, the opposite side male advocate won't say my learned friend or my learned advocate. She's saying this, she's saying. So I must say, please give me my respect in court. Don't refer to me by my gender. I am also a learned counsel. Can say a learned counsel. See, these are the things where the training is required for male advocates, I think. It is important to remember I myself have experienced this, and I told the court, let him address me appropriately. It is important to remember that despite the prevailing narrative that the law as a field is oversaturated and that success is hard to come by for anyone except the already established, I would say each and every single advocate has a place in the legal profession and is capable of finding sufficient opportunities. When you are assured of your own belonging and the validity of your ambitions, free of self-doubt and self-depreciation, even the systemic challenges become ones that can be worked on, worked around, and worked through. For young advocates who complete the requisite number of years, I must say that they should take up pro bono litigation, legal aid cases, for that gives a lot of opportunity for appearance in court. You must also volunteer to do tasks and take cases that seem daunting and you may not have too much experience with. If you are making a submission and feel spoken over or ignored in the court, this is for young advocates, you must stand your ground. You must demand to be treated at par with your male colleagues and not settle for differential treatment out of fear of conflict. In doing so, your actions form the bedrock of systemic change that prevents any form of exclusion. How should young lawyers evolve for themselves a rightful place in the profession and the society? That is sufficient to be a day-long lecture, but I'll just state a few points. I implore the young advocates to cultivate respect and unflinching obedience to your duties towards the court. Act with dignity and respect. Uphold the integrity of the judicial system. Refuse to use illegal or improper means. Apply constitutional methods, advocacy. Avoid prolix submissions. This is a special request. Avoid prolix submissions. Your duties towards your clients are providing competent representation, emotionally intelligent justice, maintaining client confidentiality, avoiding conflict of interest, communicating effectively with clients. Advocates and lawyers being constructive citizens and beneficiaries of a socially relevant legal education, I hope that you will extend your duties far beyond the confines of courtrooms and law. Many of you would be called to serve and perform duties towards the nation, duties of brotherhood and promoting harmony, duties to protect the environment, and duty towards children and future generations. These are some of the important duties which every advocate would now have to inculcate and realize. To this end, I actively encourage all of you to undertake pro bono and legal aid cases and treat them with the same importance and diligence you would in any other case. Now, our present Chief Justice of India, Justice Suryakant, has given a special impetus, and in the cause list of the Supreme Court, you have a separate heading, Legal Aid Matters. We give importance to those cases because they may be persons who are clamoring for justice by being in jail for years and decades without having remission. Thousands of days of delay because they're all jail appeals, and legal aid advocates argue them with great passion. We also notice the advocate who is arguing the legal aid briefs. It's not that we don't notice others. We notice them, but we specially notice the young advocates who with passion argue and will not give up. You see, they will not give up the briefs, the submissions. While these cases are not accompanied by famous names or so-called senior advocates or great names in the bar or the promise of high remuneration, they possess the ability to completely alter the course of an individual's life who may be in jail for a decade or more, who may have already been acquitted by the High Court, but somehow he continues in jail, or by the trial court, and must be treated with accorded significance. The ability to do so directly impact the lives of fellow citizens and is rarely available and must be given full meaning. I was a legal aid counsel in the High Court for 10 years, and therefore what I am saying today is not preaching but out of practice. A concomitant responsibility is the requirement to uphold the integrity of the profession in the course of one's work as well. As not merely an advocate representing the interests of your party, but also an officer of the court, you will play a critical role in the dispensation of justice. As an advocate, you will also be entrusted with preserving the sanctity and dignity of the court and ensuring fairness in proceedings. These duties and responsibilities bind you as much as the need to try your hardest to secure a favorable outcome for your client in court. There may be times when the two may be at odds. The onus is on you to reject favorable outcomes that are tainted and obtained through unethical and unfair means or subterfuge. While such outcomes may temporarily enrich you, they will have a necessarily deleterious impact on both your career and your conscience in the long run. Also, there is no shortcut to success. I am confident in the ability of each one of you young advocates that you would become outstanding lawyers and citizens and the leaders of tomorrow. My congratulations in advance to the winners of this tournament. My congratulations to each of the participants. I thank each one of you for your kind attention. Thank you and namaskar.
Thank you very much, ma'am. The views you expressed and the experiences you shared will surely prove beneficial and will encourage us to seek excellence in our future endeavors through moot court competition experiences, and we would also remember to say no to the temptations and yes to mutual respect.
Now, the most awaited moment of this ceremony has arrived. It's time to declare the winners of this precious moot court.
With great pride and immense anticipation, we begin by honoring those who have emerged triumphant, the champions of the distinguished competition. The winners would be awarded Rs 30,000 prize money and books from Sri Subhash Sharma Advocate. Books have also been given to all the participants by Mr. Dinesh Dudeja of Ekta Book Company since the inception of the Moot in 2005. This year, the prize winners get books from Sri Subhash Sharma Advocate, a friend of the Luthra family. In addition to the honors of being conferred, the winners and the runner-ups will get a 10,000 rupees prize, and the other categories carry a cash award of 7,500, the formal announcement of which will be made subsequently. These envelopes are on behalf of Dr. Avtar Singh Sethi, cousin of late Shri K.K. Luthra ji, who, owing to prior commitments, is unable to be present with us in the evening. I would now like to call upon Dr. Gunjan Gupta, Professor in Charge, Campus Law Center, to announce all the prize winners. For the best team and the runners-up, I request Honorable Mrs. Justice B.V. Nagaratna to kindly do the honors.
Yes, ma'am. Team done. Ma'am, winners. Number क्या होगा? Runners up क्या है? Winners. Only the winners. Only the winners have to be announced. We have an individual judge. Okay. So, ladies and gentlemen, you all are very much excited. So, I'm going to announce the winners today. Any guesses? No. So, the winners for today, 22nd KK Luthra Moot Court 2026 are the team with UR in number 1136, Symbiosis Law School, Noida. I would request the team to please come on the stage. So, congratulations to the winners, Symbiosis Law School, Noida. The runners-up for today's competition is the team with URN number 1021, the Lloyd Law College, Noida. A huge round of applause for them. You're requested to be on the stage, please. हाँ वही तो मैं कह रही हूँ वो मुझे दो ना लिस्ट
Next is the category of the best speaker and the second best speaker. The prizes in this category are decided based on the total scores of the speakers in the preliminary rounds of this competition held on 13th and 14th February 2026. The prizes being awarded in this category above are rupees 25,000 cash prize for the best speaker and rupees 20,000 for the second best speaker. The winners of this category will also be getting books, this time given by Advocate Subhash Sharma, as well as rupees 7,500 additional cash envelopes by Dr. Avtar Singh Sethi. I would request Honorable Mr. Justice Anup Jairam Bhambani to kindly give away the prizes to the winners of the Best Speaker title.
So they are runners second. So ladies and gentlemen, the next prize to be announced, the best speakers, they are Maria Robin from Christ University, Bangalore. I request Maria to be on the stage. Okay, anybody else on their behalf can come? She didn't expect. She's not well. Okay.
The prizes for the second best speaker includes rupees 20,000 as well as additional 7,500 cash envelope. For announcing the second best speaker, I would request Honorable Mr. Justice Sanjeev Narula to give away the prize for the second best speaker title.
So the second best speaker is Shambhavi Srivastava, Army Institute of Law, Mohali.
We have the best memo, and then second best I'll give it to. I need to announce this. The next category entails the Best Memorial Award and the second Best Memorial Award. The Best Memorial Awardee will be receiving rupees 25,000 and the second Best Memorial Awardee will be receiving rupees 20,000 along with books from Mr. Dinesh Dudeja. I would now request Honorable Mrs. Justice Manmeet Preetham Singh Arora to kindly give away the prizes to the winners of the Best Memorial and the second Best Memorial title.
So the best memorial goes to the team with URN number 1002, Nalsar University of Law, Hyderabad.
Second best wants to receive.
The second best memorial goes to the team with URN number 1127, National Law University, Delhi. Done. Ladies and gentlemen, please, a huge round of applause for them. Next.
Thank you very much, Gunjan ma'am, for announcing the winners. Now, I would like to invite Mr. Gautam Khazanchi, grandson of Shri K.K. Luthra, ascend to the podium and deliver the vote of thanks, please.
A very good evening to everyone here. Justice B.V. Nagaratna, Judge Supreme Court of India, Justice Anup Bhammani, Justice Sanjeev Narula, Justice Manmeet Arora, Judges of the Honorable Delhi High Court. On behalf of the Nirmal Luthra Foundation, it is my privilege to thank you all for taking out time on a Sunday. I know how important and how valuable your Sundays are, and we thank you for taking out time today to grace us on this occasion. I think first and foremost, the most important people we have to thank on behalf of the entire family and the foundation are the three pillars. And I'll just name them. You know who they are. Professor Dr. Tikku, Dean, Law Faculty, University of Delhi. Professor Gunjan Gupta, Professor in Charge, Campus Law Center. Dr. Rubina Grewal Nagra, the convener, Moot Court Society. And most importantly, we also have to thank the foundation and The foundation which is below all these pillars is the conveners and the persons who help us to organize this moot. A big round of applause for all of them, please. There are so many members and friends of not only my grandfather, but friends of the family. There are doctors, Dr. Lalita Shekhar, Dr. Gayatri, Dr. Ashwini Sethia. They all join us, every year. They support us. There are former judges. I saw Justice Amitava Roy earlier. Justice Deepak Verma is hiding behind, former judge of the Supreme Court. And also, we have former professors. We have Professor T.D. Sethi. We have Professor Khanna. We have Professor Raman Mittal, who are all here. Thank you all, sirs. I have to also thank some members who help us in this moot court competition every year. Mr. Dudeja, every year he gives books. Please, can I have a round of applause for Mr. Dudeja, Ekta Book Company. This year we have a special gift for the best speaker. I think unfortunately she is not here, but I think we'll have one of her colleagues will have to tell her. So the Parekh family, Bhagwan Bhai, there is a special gift voucher for the best speaker to go to the fantastic hotel Alila Diva in Goa and have 2 nights, 3 days stay. Lastly, I'll just say a few words. I think Justice Nagaratna spoke about the importance of having the relationship between a senior and a junior and the importance of that growing up. Ma'am, you'll be very glad to know that the success of this moot court for the last 22 years is only because of the strength of our chamber. Every year, hundreds of advocates come and judge all the rounds, and it is a testament to the chamber that this moot court is a success every year. Please, a huge round of applause for all the lawyers. I also want to make a special mention to Mr. Satyanarayan Vashisht, wherever he is. It's Satyanarayan Vashisht ji. And Smriti is here. Smriti Sinha. She's not here. And Supriya and Aditya are here, I'm sure. Are they here? Oh, they are organizing outside, as always. And lastly, I'll just thank the creator of the problem. Who's the problem creator in this case? Where is Shubhangini? Shubhangini Jain, thank you. Thank you for helping us all. And a big thank you from all our behalf. Please have a good evening, and I won't take long. I know there's a good match on later today, so we'll wind this up quickly. Thank you.
Thank you so much, sir. With this, we come to an end of the prize distribution ceremony and also the end of the magnificent 3-day extravaganza. That is 22nd KK Luthra Memorial Moot Court. See you guys next year, same time, same place, with renowned vigor and unmatched enthusiasm for another round of mooting. Until then, this is the organizing committee of KK Luthra Memorial Moot Court 2026 signing off from this August ceremony. Thank you so much. Take care and happy mooting. May I please request the August ceremony to rise for the national anthem?
पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
I request all the guests to kindly proceed for the high tea and participants to stay back for the participant certificates, please.